Dear Lordship, I'd like to mention item number 13.
Volume. Item number 13.
Yes, Your Lordship. I'm appearing on behalf of the respondent side in Your Lordship due to personal difficulties and medical emergency. So my learned counsel could not appear to
You are for?
respondent. Your Lordship.
You inform the other side?
Yes, Your Lordship, with the consent of the
Your good name?
M. Chatterjee.
M.
Chatterjee.
Miss M. Chatterjee, learned counsel for the respondent with consent from the other side. Press for listening the matter after.
Your Lordship, the date may be fixed on 3rd October.
How it possible?
After vacation, 3rd October already we are having so many people.
After
Yes, Your
vacation. Okay.
Then on 22nd October.
22nd October. Obliged, Your Lordship.
I'm for the appeal and in this matter.
Eva. Okay. Okay.
May it please, Your Lordship. The concerned with the other side, Lordship, I get to mention item number 14, Lordship.
Item number
14, value, 1-4.
1-4.
Lordship. After 2 weeks, value.
You are for
Appellant, Lordship.
appellant. Your good name?
M. Mondal, Lordship.
Mr. M. Mandal, learned counsel for the appellant with consent from the other side. Press for listening the matter. When?
2 weeks, after 2 weeks. Lordship.
After 2 weeks. Okay. Pair allowed.
Yeah, I would to mention for listing of the matter. Here you said what happened.
When?
Today, Lordship, because the trial court next date is on field. Lordship. And cross examination of plaintiff.
Today it is not possible.
2 benches are there. If
Already we have several matters. Oh, here.
time permits, Lordship.
Pardon?
If time permits.
Okay. Okay.
May it please the Lordship, I beg to mention CRP IO 20/23. We are for the respondent, and this matter is about ejectment of the defendant from suit land. So, Lordship, it was last listed in July. Thereafter, it was not taken, and I pray that it may be taken up for hearing on anytime September, like 17th September,
September 19th,
24,
19th September.
19. My senior will be on.
17th.
Others 24.
Get in. Get in. It may not be possible on
26.
16.
26th.
26. It's okay.
Okay.
26th.
Oblige.
May it please, Your Lordship. Lordship, I beg to mention item number 5, Lordship. This matter will be adjourned to the Lordship due to some personal difficulties of Mr. K. Burwa, Lordship.
Pardon?
Charge sheeted matter, Lordship.
Yes.
Next week, Lordship. Any date, Lordship. Can copy receipt, Lordship.
Mr. M. Alam,
Lordship.
a learned counsel for the accused. Press for listening the matter on
Next week, Lordship.
13th September.
13th. Pair allowed.
Highly obliged.
May please, Lordship. I beg to mention for listing higher Lordship.
When?
MSAP Lordship.
When?
On 30th Lordship.
13th.
30th.
Okay.
Okay, another more application Lordship. In MSC appeal Lordship for hearing Lordship. On
After
When?
vacation. For hearing Lordship after vacation.
After vacation, any date you can choose from.
22nd October.
May please, Your Lordship. I beg to mention one RSA for listing, Lordship. That was last posted on
When?
Friday, Lordship. In order.
Next Friday, not possible.
Monday, Lordship.
Monday, we'll try.
Yes.
Who's your Lordship? Lordship, Lordship, I beg to make these orders for
When?
Friday or Wednesday?
Friday, not possible.
Wednesday.
Wednesday, okay.
Wednesday.
May it please, Your Lordship. I beg to mention item number 3.
Item?
Number 3.
Yes.
Kindly adjourn it for the day, my lord. There is a
Why?
difficulty apart from the, I'm for the petitioner, a petition. There is a difficulty for the council. There is a difficulty for the council to appear.
Who will appear?
This is fixed.
Uh,
Item number 3. You are not informed enough. I am prepared for this.
Yes. Just now, I was instructed to give a mention, take a mention. there.
Just fixed by the honorable court last date.
No, sir,
As per your versions, your police.
When do you want?
after 1 week, my lord.
After?
1 week.
After 1 week. Okay,
Date may be fixed, my lord. Date may be fixed.
correct.
On 13 then, 13 September.
13.
What is your name?
W. Ahmed.
Learned counsel appearing on behalf of Mr.
Rituparna Bora, R. Bora.
R. Bora, learned counsel for the
Petition.
petitioner with consent from the other side. Let's list the matter on COVID
On 13th.
13.
Item for withdrawal, item number 23.
Do we have the instruction to withdraw the matter?
Yes, your good name, please.
K. Uddin, madam.
K. Uddin.
Yes.
Mr. K. Uddin, learned counsel for the appellant, submits that he has the instruction to withdraw this application, withdraw this appeal. Whether liberty will be required?
No. Already matter.
There is accordingly allowed. This RSA stands dispose of on withdrawal. Is there any interim order?
No, madam. I think
Okay.
There is no.
Okay.
Oblige.
Items for admission, item number 1.
Hmm.
May I please your lordship?
Yes.
Lordship, the petitioner, your lordship. They instituted a suit in the year 2005. There is title suit number 361 of the 2005 for ejectment of the respondent.
Yes.
Claiming declaration of right title interest and for recovery of possession claiming that he is a tenant. So that they.
So, no, you come to the point. The learned first appellate court has directed the trial court
Lordship,
to hear the matter if face and to afford opportunity
Lordship,
to adduce evidence.
Lordship.
And thereafter, the trial court had ordered it at 21/10/2020
Lordship,
had allowed to exhibit only the cell deed.
Lordship. Only sealed it.
Lord, my interpretation of this order would be that though the trial court has mentioned the sealed it only, the order for remand and additional evidence that was there, my lord, there is no restriction and such in this order for them to leave their examination in chief in respect of whatever additional evidence they want to give. So matter may be sent back to the trial court. They may be allowed to
Yes.
whatever additional evidence they have as in terms of the original high court order, if anything
well
is to be
as
adduced, that may be adduced, the date may be fixed, my lord.
Mhm.
It's simply,
We
my lord, matter of-
only agree, your lordship, that is only I have been allowed to produce the sale deed only. It is not the fact. As per.
And I believe that's not also purpose of this order, my lord.
Pardon?
That was not the purpose of this order. Though the trial court said that you filed a cell deed, cell deed has to be filed in
No,
way of additional
yeah.
evidence. In
Plain
additional
reading of
evidence, they
this
can
order
say anything they
indicates the
want,
same.
my lord.
Plain reading of the order of the trial court indicates the same, that only cell deed is allowed
Yes.
to be produced.
Lordship.
The word only is not used.
Yes,
Then the-
cell deed is specifically mentioned.
It's mentioned because the emphasis is on cell deed, my lord. The entire defect actually comes from the original prayer. In fact, in the original prayer, there was no specification as to the documents
Okay,
they want to
okay,
produce.
We'll
But then in
set-
page 75, my lord, the deeds, other documents are, my lord, mentioned. Probably these are the other documents they want to file, my lord. We have no objection.
Page
in
number, page number.
Page number 75, my lord. This is the petition for leading additional evidence, my lord.
Order 41 rule principle and application, lordship.
No, can you-
Page 75, paragraph number.
Lordship.
Para 6, my lord, at the bottom.
Okay, we'll set aside the order and remand the matter back to the
Lord-
trial court.
Lord-
You,
But
both
my
the
lord,
party appear before the trial
to
court.
adduce evidence, my lord, in terms of the
Appellate
application
Order of the
that was
appellate court.
there.
Yes.
What was there, my lord.
Kobir suggest one that
So, trial of the morning.
both the party have to appear before that.
Lordship, we have it here. In September, lordship, in the last part of the September.
Last part of September.
5 October date has been fixed, lordship.
When?
5/10.
5/10.
5/10.
510.
Lordship.
Then no date is required to be
No
fixed
date
on that day,
required,
both the
we'll
parties shall appear.
Lordship.
We'll pass the order.
Lordship.
Only thing that the evidence should be filed by that day. my lord.
Definitely we'll file it.
Yes.
The suit of 2005. my lord.
Okay,
Lord.
okay.
Definitely.
Item number 2.
May I please, tips? The petitioner herein challenge two sets of order. One is for.
So, Mr. Fukone, you have taken 16 adjournment before the trial court.
Yes, please.
What is your case?
Lordship, the petitioner has not known why her
Pardon?
counsel- why her counsel did so. So the petitioner has newly engaged.
No, but while the case was
I-
fixed for argument, where is the point for granting you opportunity to file additional WS?
Additional WS may not be, Lordship. The petitioner may kindly be allowed to face cross-examination at least. No, otherwise, he has no case, Lordship. He has reduced evidence.
Heard Mr. D. Fukon, learned counsel for the petitioner. This in this petition under Article 227 of the Constitution of India, I read with Section 151 CPC. The petitioner, Mrs. Asia Begum, has challenged the correctness or otherwise of the order dated 16/11/2022 and the order dated 38/6/2023 passed by the learned Monsif number 1 Sibsagar in title suit number 25 of 2014. It is to be noted here that by impugn order dated 16/11/2022, the learned civil judge, no, learned Monsif number 1 Sibsagar has dismissed the petition filed by the petitioner, being petition number 249 of 2022. For allowing cross-examination of the defendant. But the learned Monsif has dismissed the petition and posted the case for argument. And thereafter, on 38/6/2023, the learned Monsif has rejected the petition filed by the petitioner, being petition number 569 of 2023 under order 6 rule 17 for allowing to file amended or additional written statement for the end of justice. The Mr. Fukon, learned counsel for the petitioner, submits that the respondent herein had instituted the title suit bearing number 25 of 2014 before the learned Monsif number 1 Sibsagar for declaration and recovery of possession. Full stop. In the said suit, the present petitioner has filed a written statement and thereafter the respondent in the said title suit had filed the evidence of his witnesses in affidavit, and they were cross-examined, and thereafter the petitioner had filed her evidence, but she was debarred to face cross-examination by order dated 16/11/2022 and posted the case for argument. Thereafter, on 27/1/2023, the petitioner had filed another petition for adjournment, expressing her willingness to replace the earlier counsel by engaging a new one, and to continue with further proceeding of the suit. And accordingly, the petitioner was allowed to change her counsel. Thereafter, on 2/6/2023, the newly engaged counsel of the petitioner has filed a petition in petition number 569 of 2023, which appeared for filing additional written statement to determine the real question in controversy between the parties. But the learned Monsif, by order dated 30/6/2023, has rejected the said petition and fixed the suit on 17/7/2023 for argument. Mr. Fukon submits that the petitioner is aggrieved and dissatisfied with both the order dated 16/11/2022 and 30/6/2023 passed by the learned Monsif number Monsif Sagar, and that unless the petitioner is allowed to face the cross-examination, she will suffer irreparable loss, and therefore Mr. Fukon has contended to allow this petition. Having heard the submission of Mr. Fukon, learned counsel for the petitioner, I have carefully gone through the petition and the documents plus on record, and also perused the impugned order dated 30/6/2023 and also the order dated 16/11/2022. It is to be noted here that by order dated 30/6/2023, the learned court below had close the defense evidence, close the evidence of the defendant due to her lackadaisical attitude and posted the matter for argument. Having heard the submission of Mr. Fukon and also considering the facts and circumstances on the record, this court is inclined to dispose of this petition by directing the learned Monsif Sipsagar to allow the petitioner to fresh cross-examination when the next date is fixed.
Matter is state. Interim, there is an interim order for
Matter is state. It is provided that the petitioner shall appear before the learned trial court, learned Monsif, on or before
20th September.
20th September, and to face the cross-examination. In terms of above, this CRP stands to dispose of. Interim order passed earlier stands vacated.
quickly applies.
Item number 24, 24.
Your lordship,
Yes.
matter may be taken after few times.
Pardon?
May be taken after few times.
For bail hearing, item 4.
May it please, Lord.
Hmm.
Lordship, this till today, I have been 932 days in jail. 2 years, 6 months, 22 days, Lordship. Then, Lordship, I filed a bail petition, bail application, and your Lordship was pleased to pass an order for early disposal of the case under section 309, but it has not been complied with today.
2 years, 6 months,
Lordship,
2 years, 6 months.
2 years, 6 months, 22 days.
So how many witnesses were cited in the search?
Witness is not examined. Sorry, one witness is examined.
Five,
What?
5 PWs are there.
I picked up
One witness examined. Only one lodge.
only one.
How many witnesses cited?
5 lodge.
5.
5.
First frame no lordship 6 to 23.
So more than 1.5 year elapsed. You have been able to examine only one witness.
Lordship. And last date was lordship 16/7/24. So lordship, at least my humble prayer is any witness examined or not line the last date lordship. So up to this does may be called for till date lordship.
Lordship, one more pleading I have. So, the section 52 is not complied, Lordship. And for that, I have filed an additional affidavit and for the violation of 52A. And if 52 is not complied, then it is a waste paper. So, FSL, waste paper. And as per the Supreme Court, I will file.
So Eto, what is this? That is that compliance or non-compliance has to be determined at this stage or at the stage of trial.
Yes, as per the Caesar list, inventory, Lordship.
Hmm.
Lordship, kindly come to the page number 17, Lordship. NDPS rules 2022. These are not violated. I am reading the rules of 2020.
No. My question is whether compliance or non-compliance of 52A
Lordship.
is to be determined, is to be looked into at the time of consideration of bail or at the time of trial.
Consideration of bail of also. Lordship. I will buttress my argument with the Supreme Court's order. Muhammad Khalid and state of Telangana, and one is Mangila.
Which judgment?
Yes. Mangila is passed by Lordship.
So this aspect was looked into by the Supreme Court at the stage of appeal. The appellants were convicted.
Lordship. I think one witness Vaishak versus State of Kerala. This is on regards of bail. And depending on these two judgments, the ordinance of Kerala High Court has passed.
No, we are not bound to follow this judgment.
Lordship is more than 2.5 years. Lordship. And only one witness is examined. So
Mhm.
how many days it will remain?
If
require?
if any judgment of the Supreme Court is available on this point that there is a compliance or non-compliance of the provision of section 52A of the NDPS Act can be considered at the stage of bail.
Lordship, our court's order
Mm.
was not complied, Lordship. The section 309 is not complied as per the High Court. Page number 34.
309, are you aware of the judgment of Supreme Court in High Court Bar Association Allahabad versus State of UP? There, Supreme Court has stated that High Court cannot direct the trial court to complete the trial within a definite time period.
But Lordship passed an order to complete the.
Maybe that was prior to that judgment.
No, Lordship. This was the 4th of March of this year.
So, Mr. Goswami, you obtained the latest status report.
Lordship.
When the next when date was fixed?
It was already passed over Lordship, 16/7/24,
16/7.
Lordship.
For Mr. M. Roman, learned counsel for the accused, and Mr. Goswami, learned counsel for the state respondent. Mr. Goswami submits that out of 5 cited witnesses, one witness has already been examined, and the case was last fixed on 16/7.
16/7.
And
It was
whether any
30
witness has been
30th of
examined on that day or not, that information is not available with him, and therefore Mr. Goswami contended that an up-to-date status report may be called for from the learned trial court. But having considered the submission of learned advocates of both the parties, it is provided that SSL call for up-to-date status report from the learned trial court, fixing the matter on
This is 16th September. Item 6.
But please, your lordship.
yes.
Let the lordship earlier issued notice, asked them to procure certain instructions. Scan report. As regards the adjournments granted. And progress of the trial. As I said, my lord, earlier. The case is pending for trial, and for the last 8 months, this petitioner is inside. Search sheet has been submitted, trial has not proceeded. There is also a section under POCSO. But there is nothing apparently on the face of the records that POCSO can at all be brought in ultimately against this petitioner. Because the medical report totally negates it about any sexual harassment or abuse. Lordship may again look into it at page 25. Lordship will find it starts at page 24, that's a 5. Absolutely nothing, everything fine. I was not the named accused. Only thing is, this girl was ultimately recovered from my house because I gave shelter to her. And information was sent that she is here, she can be taken. I'll face the trial, no issue. But then, to enable me to face the trial.
At what stage the trial is pending?
Trial is pending for evidence. For evidence. They have not turned up for many days. Lordship asked for this scan report for 11 days, evidence, 11 days gone. Nobody has turned up. That's how I am now languishing. So let them take care of their proceeding, but I may be allowed to remain on bail and face the trial. Now the things are clear. What are the materials against me which are required to be proved beyond reasonable doubt? And prima facie on the face of the doctor's report, medical report, other sections are all available. 363, 344 IPC, they are all available. Both are available. Only section 6 has been brought in. And prima facie, not prima facie, my lord, what I will submit that the report which they are now relying in this search, medical report,
No, that report has to be read along with the statement of the victim girl recorded under section 164 CRPC also.
no doubt about it, no doubt about it. That
Yes.
would definitely be done. That would definitely be done and should be thoroughly cross-examined on that point also. Referring to this medical report, this medical report cannot at all be brushed aside, my lord. Medical report will definitely have its bearing. Therefore, and I was not the named because I was subsequently brought in. My charge is that how was she found in my place with my family? To that extent, yes, trial will be clear.
That is your defense case has to be considered at the end of the trial, not at this stage.
My lord, for the bail, purpose of bail, should it not be considered now? I am asking for not to be, my lord, analyzed free. I am asking only for bail on condition. I will face the trial. Kindly help me to face the trial.
Are you not facing the trial now?
Trial has been posted. Trial is considering going on, but there is no progress.
Yes, Mr. Goswami.
Lordship, my humble prayer is that the actual victim should be examined. And I have communicated with IO. He has taken back the case diary day after yesterday, Lordship. Day before yesterday. So he has not appeared yet before the IO, Lordship.
Heard Mr. Jai Islam, learned counsel for the applicant, and Mr. Goswami, learned counsel for the state respondent, learned additional PP for the state respondent. So you have no communication with him now.
My lord.
Mr. Goswami, learned counsel for the learned additional PP submits that he has not received the up-to-date case diary from the IO concerned. Then press for granting him 1 week time. Here is accordingly allowed. Mr. Jai Islam, learned counsel for the Mr. Goswami further submits that he has received instruction from the concerned IO that the applicant had never turned up in view of the order passed by this court dated 8/4/2024.
27/5. He was directed to appear before the IO on order dated 27/5/24.
27/5.
He was directed to appear before the IO. Earlier interim was granted. Thereafter, on 27th, he was directed to appear before the IO.
And thereafter also he had not appeared. Mr. Islam, learned counsel for the applicant, also submits that the applicant had not communicated with him, and also he had not appeared before the IO concerned, though specific direction was issued by this court by the order dated 27/5/2024. Under the above mentioned facts and circumstances, this court is not inclined to extend the privilege granted to the applicant by order dated 8/4/2024. Mr. Goswami shall produce the case before this court on
17/9, Lordship.
17/9.
Matter number 8, matters for hearing under order 41, rule 2 CPC.
May please your lordship. Lordship, my senior is on Lexington code number 8. So
Who is your senior?
mathematics after some time, lordship. My senior is on Lakes.
Friday, let it come Friday, madam.
Not today. As filed for by Mr. P. Upadhyay, learned counsel for the appellant, recessal is the matter on Friday.
6th.
Okay.
Item 9,
My lord, as per office note, LCR has not been received by the section concerned yet.
Well, please, Your Lordship, before coming to that, the matter has been pending since long. Matter has been pending since long. At the same time, LCR has not been recused. So at the same time, I want to highlight one thing. We came to know about the date of the respondent number 2. We came to know about it yesterday. We had mentioned the matter last week to be coming on this court, but yesterday we came to know about the date of the respondent. She has died long back, and the matter has been awaited. She has died on 28/7/2020.
28/7.
2020. Where the matter stands awaited.
2020.
2020. Since long time she has died. So stands awaited and matter is liable to be dismissed for it.
Heard Miss
M. Sharma.
learned counsel for the appellant and Mr.
S.A. Bhakhtiar.
learned counsel for the respondent.
Opponents.
Office note dated 31/8/2024 indicates that LCR has not been received from the learned trial court. And also from the learned first appellate court. Accordingly, it is provided that Justice shall issue reminder to the learned trial court and the first appellate court to transmit the records without further delay. Learned counsel for the respondent number.
Respondents.
Respondent submits that respondent number
2.
Respondent number 2 suffered demise long back on 27
28
28/7/2020.
07/2020.
The learned counsel for the appellant shall obtain necessary instruction in this regard and take necessary step on next date. List the matter after. When?
After package.
No, she has to take step.
2 weeks.
on 30th September. 30 September. Item 10,
All right.
Okay, that
Yes,
is available.
please.
So you have filed the additional affidavit.
Your lordship, it is in the record. I have flag marked it in green flag, your lordship. At the last, your lordship.
Pardon, Miss
P Das, your lordship.
P.
Preeti Das, your lordship.
Pretty Das, learned counsel for the appellant, and Madam
Ms. T. Bora.
learned counsel for the respondent. Is thus learned counsel for the appellant submits that both the parties have effected a compromise and they have filed on joint affidavit before this court on 23rd of July 2024 and enclosing one deed of agreement between the parties, which is annexed with the said affidavit as annexure number 8. And pursuant to the said deed of agreement, a sum of rupees 6 lakhs was paid to the respondent and money receipt is enclosed with this
There are two money receipts.
additional two money receipt dated 17/1/2024 and
19/8/2020.
19/8/2024 have been enclosed with the petition, enclosed with the additional affidavit as annexure number 9 and 10. And in view of the settlement arrived at by the parties, Ms. thus submits that the matter may be closed.
Appeal may be allowed.
In terms of above this, no, having heard the submission of learned advocates of both sides, and also considering the facts and circumstances on the record, this court is inclined to allow this appeal. In terms of the agreement enclosed that annexure number 8 of the affidavit dated 23rd July 2024. The agreement dated so and so shall be part of this part of the decree to be prepared.
Matter number 11,
Please apply to lordship.
With your lordship. Lordship, in this case, we filed affidavit in opposition against the I filed by the respondent side. And lordship, my senior Mr. R. Ali is on leave due to the hospitalization of his wife. Kindly fix the matter after 2 weeks.
This one pending last 7 years for hearing, my lord. And we are deprived from 12 years for the realization of area rent, more than 13 lakhs.
Oh, why this IA is preferred?
For interim application against the area rent.
Against the
Area rent against the rent of the applicant as a plaintiff. File a title suit in before the civil judge Nagaon against against the defendant for ejectment, realization of area rent along with other declaratory relief about the ownership and permanent injunctions. This suit was already decreed, partly decreed, and against that decree, the defendant filed preferred an appeal, and this was already dismissed. And appeal affirmation the judgment and decree dated 21/5/2011. After that, they filed this revision petition, and from last 7 years, this was pending for hearing only. But they did not pay the single amount as a rent to us. This was the only source of income to the petition.
Heard Mrs. M.D. Mehdi, learned counsel for the applicant, and Madam
MS Jegayam,
M.S.
Jegayam, J.
learned counsel for the respondent. Opposite party. This interlocutory application is preferred by the preferred by the applicant for issuing direction to the appellant for payment of rent, payment of arrear as well as current rent. The learned counsel for the respondent opposite party submits that leading counsel Mr. R. Ali is out of station.
Lordship, his wife is hospitalized.
So, he on account of some medical emergency, Mr.
Wait.
R. Ali, learned conducting counsel, is not present today and accordingly best for granting her some time. Where is accordingly allowed. List the matter after 1 week.
Lordship, 2 weeks.
20, date may be fixed, my lord, 20 of the
20. Okay, 20.
Much obliged.
highly obvious.
Item for hearing, item 12, part heard matter.
Please, your lordship, my senior MSR Chaudhary, she is on legs at court number 3. Matter may be taken up after some time, your lordship.
Items 15 and 16.
Well, there are two second appeal filed in the same parties, next. The item number, the 60, I mean, RSA number 60 is against an order passed, my lord, under order 2097. My lord, the first case, the other case, in which, my lord, I also filed a title suit, making the prayer, my lord, that the decree obtained by them earlier in earlier suit is not operative against me, void, fraudulent, etc. Both the cases are same. So in the other case, the Honorable Court has come to a finding that since there is a provision under Order 2197, the suit is not maintainable. That was also upheld by First Appellate Court, but subject to what the court holds in the other case. So this is not maintainable because of the provision order. Your Lordship will kindly take up then RSA number 60 of 2007. Well, Lord, I'll read the appellate order, appellate judgment. Page 9. May I read it? This appeal is directed against the order dated 8/2/2013, part with the Land Stabilities Karimabad, Miss case number 85 of 2011, arising out of titles execution case number 3/2007, dismissing under order 21/97, read with section 151 of the Code of Civil Procedure, allegedly filed by the third party. The order impugned is on the following grounds. My lord, let me, my lord, skip those grounds, my lord, grounds of challenge. Lordship will kindly come to, or may I think I better read it, my lord, in order to appreciate the facts. My lord. It is contended that the order passed D horse under 2197, 101 CPC, and D horse issued framed so and so. It has been erroneously held. The learned trial court, the third party figuring as appellants in this case, failed to prove that right titled interest. It is contended that the findings of the learned trial court on exhibit 1, 2, 7, 8, and 10 does not prove that right titled interest over the decretal land is erroneous. It is contended that Dinamoni Chaudhary, who was the predecessor of the appellants, as well as the respondents, was owner of 50% of the decretal land of the title suit number 39 of 1984, renumbered as title suit number 33 of 1995, by virtue of exchange, and remaining 50% belongs to the predecessor of the respondent, that is Deveshwar Chaudhary, after the death of Dinamoni Chaudhary and his wife. The deed of exchange is dated 4/2/60, 23/6/1952. It was executed between Dinamoni Chaudhary and Nazib Ali. Deveshwar Chaudhary is the only son of Dinamoni Chaudhary who has 5 daughters, namely Suchitra Bala Roy, Mathura Namashudra, Alanno Roy, Sukumari Roy, and Maluti Roy. Suchitra Bala Roy is the mother of appellant number 1, Rama Roy, and Alanna Roy is the mother of appellant number 2 and 3, Dharani Mohan Roy and Tarini Mohan Roy. It is germane mentioned at this stage that during the pendency of this case, appellant number 2 and 3 died and the legal heirs were substituted. The names of Putul Roy and Dhiraj Roy were substituted as appellant number 2-1 and 2-2 in place of late Dharani Mohan Roy, and names of Tanuj Roy and Shutapa Roy were substituted in place of appellant late Dharani Roy. Srimati Shipra Aditya, Srimati Shivani Chaudhary, Srimati Bhupani Chaudhary, Srimati Bani Chaudhary, and Onani Chaudhary were arrayed as respondent number 1 to 5, and Dulon Pal, wife of Moni Pal, the daughter of Dharani Pal, was added as respondent number 6 by amendment dated so and so. Again, it is the apt to mention here this stage that the order dated 7/8/2013 reflects that the respondent number 6's name was substituted as the respondent because she denied sign of Okalatnama to implead her as substitute appellant. The only son of Dinamoni Chaudhary, that is Deveshwar Chaudhary, was the owner of 50% of the aforementioned decretal land left behind by Dinamoni Chaudhary, because after the death of Dinamoni Chaudhary's wife, the daughter Mathura Namashudra, who had no children, the remaining 4 daughters, Suchitra, Maluti, Alanna, Sukumari, and only brother Deveshwar Chaudhary became the owner of 1/5 of the part of the property of Dinamoni Chaudhary, which is a part of the suit land. In this manner, the alleged third party, that is the petitioners, have right, title, interest, possession over the decretal land of the aforementioned title suits. The bone of contention is that Dinamoni Chaudhary died in 1956, prior to the enactment of Hindu Succession Act 1956. But the PW1 has falsely stated that Dinamoni Chaudhary died after the enactment. The decision of the landed lower court has also been impugned on various other issues, which will be decided in the appropriate stage of the sake of brevity. The contentious issue is that the landed trial court held that the written statement of Sukumari Roy in title suit number 6 of 2007 is a public document which can be included.
Yes, Mr. Roy, what is the substantial question in this question
My
of
lord,
law in this
substantial
appeal?
question is, in this case, whether that is, your lordship will find and dated 1/3/2017, whether the suit of the appellant plaintiff praying for declaration that the judgment and decree dated so and so respectively, passed in title appeal number so and the subsequent no, it is 59, 16. No, well, I think it is in the other case. So she will pay that is order is 1/3/2017 pass RSA number 60. Lordship is getting whether the findings of the learned courts below that Dinamoni Chaudhary has having died prior to the coming into force of Hindu Succession Act 56, his widow or daughters did not inherit any of his properties sustainable in law, being in conflict with the provision of Section 3 of the Hindu Women's Rights to Property Act 1937, vesting limited interest on the Hindu widow, which having become a full-fledged inheritable property right under Section 40 of the Hindu Succession Act, whether the landed courts below were right and relying on the Exhibit E written statement of Sukumari filed entitled suit number, the content of which being not tested in cross-examination. But these are the two. Well, the limited issue is, my lord, in fact, what happened, my predecessor from whom I succeeded, the defendants, I mean, the case is that he died prior to 1956. The Dinamoni Chaudhary died prior to 56, came into force. Now, my lord, prior to 56, the rights of the widow was limited. His wife, I succeeded from the widow, from the wife of Dinamoni. Now, my lord, it was limited. After the 56 Act came into force, that right is perfected, my lord, full-fledged right under Section 14 in the Succession Act. So that is the only question. Well, Your Lordship will kindly have a look at the provisions of the Act. I just.
Okay. Success.
Lordship will have a look at this after those interpretation.
No, itu baik sih. Ikon kemudian succession.
Section 3. When a Hindu governed by Dayabhago School of Hindu Law dies intestate, leaving an interest, and when a Hindu dies intestate, leaving separate property, his widow, or if there is more than one widow.
This act was prevailing at the relevant point of time.
Relevant point. In their case, our case was that he died after that, but the court below found that he died before that. Even if it is before that, then we have the right, my lord, because of this provision of the Act, because my mother was entitled to the property to the limited, to his life estate. After the new Act came into force, 1956 Act. I don't kindly see Hindu Succession Act. Section 14. Lordship, got it.
Yes.
Section 14, Lordship will come to. It says,
Yes.
my lord,
Yes.
any property possessed by a female Hindu, whether acquired before or after commencement of this Act, shall be held by her as full owner thereof and not as limited owner. So earlier it was limited, my lord. Now after the Act came into force, it became perfect and it is a full-fledged owner, female, the widow, my lord. So if that be so, the widow died after 56 Act came into force. If after 56 she died, she acquired the full-fledged right into the property of her husband, the share, 50% of the share, because land was originally belonging to two persons, Dinamoni Chaudhary and Deveshwar Chaudhary. Dinamoni is our predecessor in interest, 50-50. So far as 50% interest is concerned, the widow succeeded along with Dinamoni, Deveshwar. His son, Deveshwar was his son. And therefore, my lord, court, even if has held that Dinamoni died prior to 56, our right cannot be taken away to succeed to the
because
property.
of this act. Because of this.
Because of these provisions of the and the subsequent 56 Act.
So which section is irrelevant? This 1937 Act.
That is section 3. It says when a Hindu governed by the Dayabhaga school of Hindu law dies intestate, leaving any property, And when the Hindu governed by any other Hindu law or customary law dies intestate, leaving separate property, his widow, or if there is more than one widow, all widows together shall subject to the provision of section 3 be entitled in respect to the property in which he dies intestate and the same share as a son. She acquires as a son, provided that the widow of the predecessor son and inherit manner if there is no son surviving of the predecessor son shall inherit like manner. Provided further that the same provision shall apply mutandis to the widow of the predecessor son. When the Hindu is governed by school of Hindu law other than the above, that is different. So when she succeeds along with her son after the death of her husband, we now succeed from the widow. We are successor interest of the widow. Therefore, her daughters are entitled to the property. Because of the provision of section 56 Act. Female share can go to the successors. This is one issue. This is one substantial question. Other was the learned court below, my lord, relied upon a written statement. Though trial court has held, we do not go into this, but the appellate court has relied upon the written statement filed by one of our mother, I'm one of the predecessor interests, saying that we donated the property to the Deveshwar Chaudhary, their predecessor interest. Now, that written statement was filed in the other case. So, the written statement who filed by the defendant number 2 never came to the witness box. It was never proved. Just written statement is a pleading. Pleading is not a proof, So pleading has to be proved by appearing in the witness box. Her case must be proved. She was not a witness. Therefore, that written statement ought not to have been relied on by the learned court. That is also a substantial question of law. Second substantial question. These are the two
Substantial questions.
questions of law. Admitted position is we are successor interest with the widow of the Dinamoni Chaudhary, and the defendants are the successor interest of son of Dinamoni Chaudhary who jointly own the property. May I read the judgment?
Yes.
Well, I read from the background facts. No, para 6 also, I did not read it. Para 6 should be read. Bone of contention is that Dinamoni Chaudhary died in 1956 prior to the enactment of Hindu Succession Act 56. But PW1 has falsely stated Dinamoni Chaudhary died after the enactment. The decision of the learned lower court has also been impugned on various other issues which will be decided in the appropriate stage and so. The contentious issue is that the learned trial court held the written statement of Sukumari Roy entitled suit number 6 is a public document which can be included as an evidence. The document can be given in evidence, but it has to be proved. The contention must be proved. Next is the background facts. The genesis of the case was that decree holders of title suit number 3984 filed in title execution number so of Khas possession of the decretal land by eviction of the judgment debtors who were licensee of the decree holder DW1. With respect to the decretal land, the appellants in this case, who are third-party petitioners, namely Roma Roy, Toroni Mohan Roy, Sagar Chandra Bisha, resisted the execution of the decree and filed objection. Decree holders then filed a petition raising objection against the resistance of the present appellants with respect to the suit land. Then the present appellants filed petition number so under Order 2197, read with 151 CPC against the proposed execution of the decree. A miscellaneous case was registered based on the said petition on 3/11/2009 under Order 2197, read with 151, miss case number so. decree order figuring as OPs in the present appeal filed written objection. It was contended that late Dinamoni Roy and his son Deveshwar Roy became the owners of the land mentioned in the schedule of the petition, including the suit land by deed of exchange number so and so dated 23/6/1952 of Karimganj sub-district, which is executed between them in one part and Najib Ali Chaudhary on the other part. This deed of exchange was executed after Dinamoni Chaudhary and his son Deveshwar Chaudhary and daughters and his wife migrated to India from Bangladesh. Jogeshwar Chaudhary and Mukteshwar Chaudhary were licensee under Dinamoni Chaudhary and his sons. And both Jogeshwar Chaudhary and Mukteshwar Chaudhary are residing in a house constructed on the land described in the schedule of the petition. Dinamoni Chaudhary died, leaving behind his son and 5 daughters and his wife. All the daughters migrated to India from Bangladesh in the first part of 1950. By virtue of the deed of exchange, Dinamoni Chaudhary and his son became the owner of the land to the extent of 50% each. It is hereby pleaded by the third party figuring as appellants in the case that after the death of Dinamoni Chaudhary in 1956, Deveshwar Chaudhary and his 5 sisters, mother inherited the scheduled property land jointly and acquired right title, interest and possession thereon. Jogeshwar Chaudhary and Mukteshwar Chaudhary are also continued to reside in the house as licensee under the descendants of the Dinamoni Chaudhary. Subsequently, Dinamoni Chaudhary's wife died, leaving behind Deveshwar Chaudhary and his 5 sisters. One of the sisters, Malati Roy, died, leaving behind Sagar Bishas, appellant number 4. Suchitra Bala Roy died, leaving behind Roma Roy, appellant number 1. Olanna Roy, mother of appellant number 2 and 3, and Dharani Mon Chaudhary also passed away. Accordingly, Deveshwar Chaudhary and his sisters, Sukumari Roy, since deceased, and appellants, and another co-sharer, Ranjit Roy, continued to occupy and possess the suit land and the house standing thereon. As such, the appellant have claimed right, title, and interest along with the decree holder in Asmali over the scheduled land, along with the house standing thereon. They have also claimed that they have constructed possession over the land and house. It is the further contended that on 1/5/2007, the appellants who are also third party learned that decree holder DH1 in collusion with his sister Sukumari Roy and licensee Jyotirmoy Roy filed a title suit on 39/84 with false and concocted averments against the licensee Jyotirmoy Chaudhary and others, and procured the decree with respect to third scheduled land of the execution case and house mentioned in the fourth scheduled land since the knowledge of the third party appellants and their predecessor. They also further came to know that in the said title suit, the share of the mother of the decree holder and his 5 sisters over the land, that is first schedule of the plain, and the suit were shown as donated in favor of the registered deed number so and so on dated 26/9/62, Karimganj Sub-Registry Office. It is contended that the said gift deed is collusive, illegal, and is mentioned as Suchitrabala Bishas and Sukumari Bishas, who were Deveshwar Chaudhary's sisters, were shown as resident of Rilampur, Silhet district of Bangladesh, and they were shown to be represented by attorney advocate Sri Brajendra Chandra Chaudhary. It is contended that the will deed is executed by one of the advocate, but not the person who donated. It is contended that at the time of the alleged execution of gift deed, Suchitra Bala Bishas and Sukumari Bishas were Indian citizens. The attorney fraudulently represented them. Both Suchitra Bala and Sukumari Bishas have denied the execution of such gift deed and power of attorney in favor of Deveshwar Chaudhary. It is also contended that filing of the title suit number so and so, subsequently renumbered as so and so, and number so and so, a decree was obtained fraudulently and this sought to be executed, therefore the title execution number so, in order to grab the properties belonging to Deveshwar Chaudhary's sisters, that is predecessor of the present appellant and third parties. It is contended that if the decree was challenged by the appellant through title suit is enforced, the appellant will suffer irreparable loss so and so. It is stated the appellants being legal heirs of the deceased Sukumari Roy are entitled to 1/10 share of the suit property. Similarly, appellant number 2 and 3 of the brother of Ranjit Roy is also entitled to 1/30th share, that is 1/10 jointly of the suit property, and the share of the decree holder, that is Deveshwar Chaudhary, and his legal heirs to the extent of 6/10 of the suit property. It is also contended that both the parties are in joint possession and occupation of the suit property. Even though their status licensee. It is contended that with the force of the decree holders are trying to deprive the right title and interest of third-party appellants over the land mentioned in the schedule of the prop petition so and so. They prayed for adjudication of the right title and interest. On the contrary, the decree holder figuring as respondents filed objection, denying all the claims and objections of the appellants. During the pendency of the execution, Deveshwar Chaudhary died and his legal heirs were substituted as stated. It is contended that appellants in collusion with the joint judgment debtors have tried to create embargo in the lawful execution of the decree in favor of the decree holders. Issue. Whether the third-party petitioners have right title interest over the decretal land as aforesaid so and so, whether the third-party petitioners figuring as appellants in the case have right to resist, obstruct the delivery of decretal land so and so. Decision. I have carefully scrutinized the relevant documents and order in the learned trial court. The learned trial court gave a sound reasoning while deciding the case. It was decided that Order 2197 makes it mandatory that when an application is made under Rule 1, the executing court is to follow the provision Order 21 read with 101 CPC, which states that all questions, including the question related to right title interest of the property arising between the parties to the proceeding on an application 9799 or the representatives and relevant to adjudication of the application, shall be determined by the court dealing with the application and not by a separate suit for the purpose of court shall notwithstanding anything contrary to any other law of the time in court deemed to have jurisdiction to decide the question. And it has been observed by the Honorable Supreme Court in so and so as 2004-11 that the provision Order 2197/99 have been widely and liberally construed to enable the executing court to adjudicate interstate claims of the decree holder and third party in adjudicate proceedings themselves to avoid prolongation of the litigation by driving the parties to file independent suit. I have relied on the decision of the Supreme Court and I hereby proceed with this one. To fortify the stance, third-party petitioners figuring as appellants in this examined 3 witnesses and exhibited certain documents including voter list, certified copy, registered gift deed dated so and so. On the contrary, decree holders figuring as opposite party cross-examined the witness and submitted certified copy of written statement submitted by Sukumari Roy in title suit number 6 of 2007. The decree holder, that is office, also adduced evidence to buttress their claim. It is clearly been admitted by the appellants decree holders Deveshwar Chaudhary had right title interest over the scheduled land and the house standing thereon to the extent of 6/10 of the share. It is also admitted the judgment debtor Deveshwar Chaudhary and Muktesh Chaudhary were licensee under the decree holder with respect to the scheduled property. We also said, but they are also licensee under us, our predecessor interest. It is also admitted that Dinamani Chaudhary died in the year 1956. The decretal land in title suit number 3884 and the house standing thereon is the same decretal land by the third party petitioners in the petition number so and so. They have claimed right title interest over the scheduled land and the house on the strength of inheritance from the predecessor, namely Suchitra Bala Roy, mother of Roma Roy, Malati Roy, grandmother of Sagar Bishwas, Olonna Roy, mother of Malati Roy, and Dhorini Mohan Dev. It is contended that the attorney Brajendra Chandra Dev fraudulently represented Suchitra Bala Bishwas, mother of Rama Roy, and Sukumari Roy, sister of Deveshwar Roy, as residents of Bangladesh. This power of attorney is also not proven. It is also contended that both Suchitra Bala Roy and Sukumari Roy were Indian citizens at the time. But the learned advocate Brajendra Chandra Dev fraudulently represented them as foreign nationals for the execution of a gift deed dated so and so. It is hereby contended that alleged fraudulent deed is illegal and not enforceable in law. To buttress their stance, PW1, Tarini Roy submitted his examination chief, which reiterates the above petition so and so. In cross-examination, he admitted that they have filed title suit 607 with respect to the same subject matter regarding this case number so and so, arising at title suit number so and so. The appellants have admitted through the petition number so and so that Dinamani Chaudhary died in the year 1956, leaving behind Deveshwar Chaudhary, his son, 5 daughters. It is admitted that appellants have filed title suit number so and so, impleading Sukumari Roy, mother of Rama Roy, as defendant number 2. The decree holders have submitted that certified copy of the written statement wherein Shukumari Roy was arraigned as defendant number 2 entitled suit 607. The written statement was read as public document by the learned trial court, and public document and the recitals of the written statement also came into existence in connection with the miscellaneous case. Shukumari Roy admitted in written statement that her father Dinamoni Choi died in the month of February 1956, leaving behind the degree holder Deveshwar Chaudhary and his 5 daughters, his widow. Though
I'll give my reply at 2 o'clock when let him complete. Because in court number 1, there is one matter.
through the said written statement, it is also admitted that 5 daughters of Dinamoni Chaudhary executed disputed gift deed number so and so dated 26/9/1962, donating 6/7 over the decretal land and other land in favor of their brother Deveshwar Chaudhary. It is also specifically stated that at the relevant time, the execution and registration of the gift said deed, Shukumari Chaudhary was residing in her mother-in-law's house at village Hasanbad under Jakiganj PS at Bangladesh, and her elder sister Suchitra Bala Bishwas was also residing in her brother's sister house at village Bangladesh. And so the gift deed was executed on their behalf, attorney Brajendra Chandra Dev, and has executed the gift deed on behalf of the 2 sisters. This part of the evidence is the bone of contention in this appeal. The learned counsel for the appellant submitted that the learned trial court committed gross error while admitting the written statement entitled suit number 6 as a public document. In this context, my opinion is that evidence has been taken into consideration, it has come on record, and it cannot be undone. How it cannot be undone? Since evidence is there, I am disputing. So the appellate court said, no, I won't look at it because evidence is there. So this cannot be the finding. This is completely erroneous. Moreover, the written statement can be taken into consideration in connection with the case because it has been categorically admitted in the cross-examination that title suit number so is regarding the same subject matter in such case. The argument of the learned counsel for the appellant that the learned trial court erroneously considered the written statement entitled suit number 6 of 07 as a public document and decided the instant case is groundless. Moreover, the contention of the registered deed dated so and so fraudulently executed on so and so 62 executed exhibit 30 has also not blush to stand. The gift deed was indeed properly executed by all. This is wholly perverse. This gift deed is executed by the power of attorney of 2 of the persons who donated. This power of attorney was not executed in evidence, not proved in evidence. So how can this
not marked as an exhibit?
As an exhibit, it should be exhibited, and prove that yes, power of attorney has been given to us, given to the advocate to execute the gift deed on behalf of persons who reside in Bangladesh. In fact, the persons we said they were very much here. The power of attorney must be executed. I mean, they must be proved in evidence and exhibited. Regarding death of Dinamoni Chaudhary, the next question comes, death of Dinamoni Chaudhary. The decision of the learned trial court as well as the evidence elicited in the case has been taken into account. Srimati Romarai testified in PW1 that she is the granddaughter of Dinamoni Chaudhary. She testified that after the husband's death on 12/8/2012, while she and her nephew, appellant sister Thakur Bishwas and other family members were clearing the house, they came across the death certificate of Dinamoni Chaudhary issued by Dr. Kunjunal Mollik on 20/11/1956, wherein it is mentioned that the grandfather of Dinamoni Chaudhary died in 16/10/56. By proving this, we want to say since the 56 Act came into force in June 1956, so the person died after that. Therefore, the 56 Act is applicable. But then we abandon this plea. Even if we abandon this plea, because by virtue of the other act that I've shown before, 37 Act.
No, the death certificate is marked as Exhibit 16.
Exhibit 60. That certificate, that is our exhibit. We have exhibited. We say that Dinamoni Chaudhary, because of this death certificate says they died on 16/11/1956. So it is therefore essentially after the 56 Act came into. Therefore, we say 56 Act is applicable to us. They cannot raise the plea since the nominee died prior to 56 Act coming into force. So the widow cannot succeed. This is their case. So we as against that exhibited this. But then the trial court did not believe this piece of evidence. I'll read further. Exhibit 16 is the death certificate dated 20/11/1956. These evidence of PW1 is corroborated by
Who had issued this certificate?
by a doctor. We said by a doctor, but doctor's son has proved his father's signature. This is 1956. This is by a doctor, we said. Then pharmacists were also called doctors. But then his son came and says, I know my father's signature. This is the certificate issued by. But we may wonder because the trial court.
Why don't you examine the doctor?
Doctor is dead, my lord.
Acha.
Doctor is dead.
Acha.
56, my lord, long back.
Mhm.
The evidence of PW1 is corroborated by the evidence of Sagar Bishwas PW2. He stated in his evidence that his grandmother Malati Bishwas was Dinamoni Chaudhary's daughter, and his grandmother died leaving behind his mother Minu Bishwas as her heir and successor. Consequently, he is the sole heir of successor of Minu Bishwas, who died about 17 years ago. His evidence depicts on 12/8/2012, after the death of Roma Roy's husband, while cleaning the utensils and goods from the house, Roma Roy came upon the death certificate of Dinamoni Chaudhary. This we said when we got it during the after that. Now, next para 18. PW2 was cross-examined in extenso. The relevant part of his cross-examination will be discussed at the appropriate stage. The evidence of PW1 and PW2 is also supported and corroborated by evidence of PW3. Komalendu Mallik stated in Komalendu is the son of the doctor, PW3, that his father was a pharmacist. His father, Kunjalal Mallik, died in the year 1981. The death certificate, Dinamoni Chaudhary, Exhibit 16, was signed by his father. Exhibit 16(1) is father's signature, which is familiar to him. The evidence of PW1, 2, and 3 has been rebutted by the evidence of opposite party. Shivani Chaudhary gave her evidence as DW1 that the respondent's number 1, Shipra Aditya, is her elder sister and she resides with her in-laws and she is married. She further stated in her evidence that on the last part of April 2013, that is 28/4/2013, while sweeping the courtyard in the morning, she suddenly came across a few pieces of old, tattered and faded blank papers and on the garbage near the approaching path of their homestead. When she picked up the papers, she found 2-3 pieces of paper bearing a blue-colored seal consisting name of Dr. Kunjalal Mallik. As she had no hint why these papers were lying strewn over the area, she collected those papers and kept them in veranda. After 2-3 months, she employed one lever to clear the drain on the backyard and of their homestead. And after cleaning the garbage, she noticed one old seal and picked up the seal. And when she used the seal, she noticed the same imprint, Dr. Kunjalal Mallik. The papers were discovered on 28/4/2013, and the same seal which was later discovered while cleaning the drain. She further stated in her evidence that Exhibit 16 is fake and manipulated document created by the judgmental in connection. This is the both parties of the case. My case is that Kunjalal was a doctor. They said we found out a seal from the veranda while cleaning. Essentially, this seal is prepared by us to manufacture this certificate. This is the cases of the parties. Now, at this stage, I would like to draw attention to the cross-examination of PW1, wherein he has vehemently denied that Exhibit B series are the same lot of papers used while preparing Exhibit 16. He has admitted that seal over Exhibit 16 marked Exhibit A1 and the seal impression marked as Exhibit B appears to be similar. DW1 further stated in her evidence that Jyotirmoy Chaudhary, who was the judgment debtor number 1 in execution case number so and so, deposed DW1 on 31/3/89 in the original title suit wherein he was erased as defendant number 2. In page number 19, the certificate copy of the said deposit clearly stated that Dinamoni Chaudhary died on 1st of February 1956. Exhibit C is the attested copy of the death certificate. Exhibit D is the certificate copy of the deposition of Jyotirmoy Chaudhary and so and so. The evidence of Shivani Chaudhary is supported and corroborated by the evidence of Rupasri Das. She is dealing assistant in the court of Civil Judge Karimganj. She testified as DW2 that after the promotion on so and so, she has been working as dealing assistant. In the year 1989, she was working in the copy plant. Exhibit E is the certificate copy. She prepared the certificate copy of the deposition DW1 entitled suit number so and so in the court of Western District Judge, presently civil judge. The certificate copy was issued on 29/4/89 by Sharistadar Kamalendu Bhatt Chaudhary, and it was compared with the comparing assistant Nirmal Kanti Das during the lifetime. Exhibit E is a signature on the last page of certificate copy. It is a copy of deposition of Jyotirmoy Chaudhary as DW1. He was the defendant number 2 in the title suit number 39/84. She further testified that she prepared Exhibit E certificate copy of the original deposition DW1. The original deposition DW1 in title suit number so and so has been called for from the court of civil justice. Exhibit E is the original copy of deposition DW Jyotirmoy Chaudhary in title suit number so and so. The original exhibited under objection appellants. The contention of Exhibit E are similar. It is mentioned in the deposition of Exhibit E that Dinamoni Chaudhary died on 1st of February 1956. Exhibit E1 is the relevant portion. Rishikesh Goswami was the then Eastern District Judge who recorded the deposition of Exhibit E.
Resume after 5 minutes.
Yes.
Paragraph 25, I will read below.
Yes.
Moreover, to rebut the death certificate, there is more clinching evidence in the form of deposition of Jyotirmoy Chaudhary. The evidence of Jyotirmoy Chaudhary is accepted on the touchstone of preponderance probability. There is indeed a ring of truth in his evidence instead of so-called death certificate issued by pharmacists, which was discovered in an unrealistic manner to suit the purpose of the case. New facts emerged, which are enduring for all these years. The title suit was filed in 1984, and thereafter it carried till the appellate stage, a final leg of so-and-so. The evidence appears to be contrived. I do not find any the evidence of DW1 acceptable. Moreover, certified copy of pharmacist cannot be accepted. So the evidence of Dinamoni died in 611 is not accepted. The defendant document Exhibit 16 is not a valid document. Such kind of certificate cannot be accepted. The evidence of Jyotirmoy Chaudhary testified in DW1 and so. Dinamoni Chaudhary died 56 and so. So, my lord, my lord will kindly have a look at the written statement of page 55, my lord. Page 55, lordship will kindly see which they are relying on. This is the written statement. They say filed by 55. Yes, no. Oh, 50, 56, 57. This is the written statement. They say that Sukumari Roy has filed in the other case that I have filed. This written statement, if your lordship kindly come to the affidavit page 61. This affidavit is shown by his son in the written statement, and verification is RTI of Sukumar. So, my lord, the statements, this affidavit, my lord, is a defective one. He cannot to prove whether they had donated or not. This has to be based on some. How can his son know, my lord, the fact? And by swearing affidavit, he says, "I know based on knowledge." This is a defective affidavit. Now, that apart, my lord, this Sukumari Roy did not come to the witness box in the other case. Therefore, this cannot be relied on. This is what the substantial question of law is. Now, my lord, may I also told my learned friend, my lord. My lord, can it be further taken up on Monday next, my lord? Monday. My learned friend also-
Next Monday.
Next Monday.
Why?
Because I have some cases, other cases for me. That's why, you know.
So this is less important to you.
No, it's not that, my lord. Your lordship will keep it part-time.
Mr. Mazumdar?
Or I can continue this.
I leave it to your lordship.
I can,
Okay.
if my learned friend
Otherwise-
has some objection, I can continue. There's no.
No, otherwise I was free today, but if my learned friend has got difficulty, I'll not object to my learned friend's prayer.
Okay.
But in place of Monday, let it be on Tuesday, madam. Tuesday is the
Tuesday.
hearing day.
Tuesday is
Tuesday.
better.
My lord. Tuesday is the
Okay.
hearing day.
Your lordship will keep it part.
Okay. Heard Mr. P.K. Roy, learned senior counsel assisted by Mr.
SK Chakravarti.
learned counsel for the appellant, and Mr. D. Mazumdar, learned senior counsel assisted by Mr. Besos, learned counsel for the respondent. Heard in part, list the matter on Tuesday for further hearing as parted. Both the matter is 59 and 60.
Oh, it's together.
Same.
Okay.
Lordship will kindly mention the date, my lord, 10th of September.
10th of September. Okay, okay.
10th is Tuesday, is 10th of September. Otherwise, there will be confusion to only Tuesday. Obliged.
Item 17.
RFA, my lord, against dismissal of the suit, my lord.
Who is for the other side?
He's coming, Mr. Rakesh Dubey is for the other side, he is coming.
So, so you want to start?
My lord.
Okay.
Well, case is that I was awarded one license for opening one sweet and salty parlor at the LGBI airport at Guwahati. By exhibit 1, that is the, can you see that see file, my lord?
Exhibit 1
Exhibit 1.
at page number.
Exhibit 1, my lord. Sorry, I have separately, my lord.
Exhibit 1 is the judgment in title suit number 40.
Yes, sir.
Yes.
the award of license granted to Mr. Devendra Setia, that is the plaintiff, for opening a sweet and salty parlor at LG Bay Airport. Accordingly, I deposited the electricity security as provided by the license agreement. And after approval of the rates, etc., I commenced the business. Subsequently, my lord, during continuance of the business, by Exhibit 7, I was issued one letter by the Airport Authority of India stating that the security bank guarantee for security deposit of rupees 4,08,420 is a fake bank guarantee, as stated by the State Bank of Bikaner Jaipur, saying that they have not issued this bank guarantee. And I was asked to furnish my so-called reply. Against that so-called reply, my lord, by Exhibit 8, I replied to them that it may take time, and I may be allowed to furnish either PDC postage checks of the similar amount, or I may be allowed to arrange for other bank guarantees. But that was not considered, and thereafter by Exhibit 9, my lord, the same thing allegations were given that the bank guarantees are fake, and subsequently my license was cancelled, and I was asked to vacate the premises. Then by Exhibit 11, my lord, I requested them to, sorry, by the Exhibit 11, it was informed to me that entry passage of my employees have been cancelled, and I was asked to hand over the premises by 5th May 2008, by the Exhibit 11. And by Exhibit 12, I was informed by the Airport Authority of India that a sum of which 2,43,744 is pending against me, and I asked to pay that amount. Then by Exhibit 12, my lord, I deposited the sum of which 2,43,744 and requested them to allow me to remove my belongings. But thereafter, in spite of series of correspondence between me and the Airport Authority of India, I was not allowed to remove my belongings and furniture, fixtures, and air conditioners, and these things. And subsequently, I was blacklisted from participating in the AII tenders for 3 years. And while blacklisting me, that is Exhibit number 20 is the letter of blacklisting me, I had another restaurant also, that airport restaurant, that was also clubbed. So again, that I issued one letter, notice under 80 CPC, asking them to pay a sum of rupees, all total 37,95,317 towards my structure, furniture, and these things, because I was not allowed to remove my belongings and these things. But they did not concede to that, and ultimately I had to file the suit, my lord. In the suit, my lord, they have appeared and taken the plea regarding the fake bank guarantee, and although the fake bank guarantee is not yet declared till today by any court that the bank guarantee is fake. And in the WS, my lord, they have stated that they have denied about my investment in furniture, fixtures, and these things. Although in the cross-examination of the DW1, they have not denied regarding my investment in these things. Kindly see, my lord, the cross-examination portion of the DW1. I'm reading that.
Have you enclosed the same along with this petition, along with this appeal? No.
My lord.
Have you enclosed the evidence in this appeal?
My lord.
Have you enclosed the evidence of DW1 along with this appeal?
No, my lord, that I am not. The records are there, my lord. Only one PW and only one DW.
Yes.
I am reading the cross-section portion, my lord. Exhibit one, actually, in my case also, I have exhibited, marked the document as exhibit 1, 2, 3, and 4. And in the DW also, they have marked it, they have not exhibited as ABC, like they, and they have also mentioned as exhibit 1, 2, and 3. So this in cross exhibit 1, in their exhibit, is the authorization in my name to represent the airport director, Airport Authority of India, having office at LGBI Guwahati. The said authorization letter is dated 3/12/14. By this authorization letter, I am representing only the defendant number 1. I have not filed any other authorization letter in my name. Defendant number 1 is the Airport Authority of India to represent the defendant number 1 prior to 3/12/14. I am working at LGBI Airport Guwahati since under the establishment of Airport Authority of India since September 2007. Presently, I am serving as manager air traffic control and functioning in the said capacity since joining LGBI Airport Guwahati. Since 2012, I am also looking after the commercial activities and matter of Airport Authority of India, such as allotment of spaces for commercial use at LGBI Guwahati by allottees prior to 2012. I had not dealt with the commercial matters of AAI at LGBI Guwahati. Exhibit 1 does not show specifically the word to give evidence on behalf of Airport Director. It is not a fact that by the Exhibit 1, I am not authorized and competent to give evidence for the defendant. It is not a fact that Exhibit 1 is an invalid document. My evidence is entirely on the occurrences which took place in the year 2008. The present suit relates to the commercial space provided to the plaintiff by the defendant. I was not dealing with the commercial matters during the period involved in the suit. Whatever evidence I have given and I am giving are entirely based on the documents filed with my evidence and on the basis of briefings when I took over the charge of commercial activities of AAI and not on my personal knowledge. In December 12, I took over the charge of commercial activity of AAI, LGBI, Guwahati from Suresh Rajkumar. In my evidence, I have not stated anything regarding my taking over charge of commercial activity in December 12. And I have also not submitted any document regarding it. It is not a fact that I am only manager air traffic control and I am not assigned the task of commercial activities of AI. Exhibit 2 is not a listed document filed with the written statement of the defendant. I have no knowledge as to whether any permission is taken or not by the defendant for introduction and admission of Exhibit 2 in my evidence. Exhibit 2 nowhere bears the signature of airport director on any of the pages and on Annexure 1 annexed to the Exhibit 2. It is not a fact that Exhibit 2 and Annexure 1 annexed to the Exhibit 2 being not signed by airport director is not enforceable under the law. It is not a fact that Exhibit 2 is not an agreement. In para 2 of my evidence and affidavit, I have not stated specifically the words default, failure, negligence, or breach under which the license agreement can be revoked. The bank guarantee mentioned in the para 3 of my evidence has not been declared or held to be fact bank guarantee by any court. The original of Exhibit 3 is in Paltran Bazaar Police Station, police custody. I cannot say when the original Exhibit 3 was seized by police. I have not exhibited concerning seizure of original copy of Exhibit 3. My lord, Exhibit 3 is the bank guarantee, that bank guarantee. The bank guarantee mentioned in para 3 of my evidence has not been declared or held to be a fake bank guarantee by any court. The original of Exhibit 3 is in Paltran Bazaar Police custody. I cannot say when the original of Exhibit 3 was seized by police. I have not exhibited concerning seizure of original copy of Exhibit 3. In my evidence also, I have not stated about seizure of original of Exhibit 3 by police. I have not filed any application for admission of Exhibit 3, which is a photocopy in evidence. I cannot say whether Exhibit 3 being photocopy is admissible or not in evidence. It is not a fact that Exhibit 6, 7, and 8 and 9 are not related to the suit. These are the correspondence between the bank and AAI. It is also not a fact that Exhibit 6, 7, 8, and 9 being photocopy are not admissible in evidence. Or if we don't have the originals of Exhibit 6, 7, 8, and 9, I have not taken any step to call for the originals of Exhibit 6, 7, and 8, 9. I have no personal knowledge of the contents of para 4 of my evidence, and the same is on the basis of the documents, briefings, and on my hearing from the officers who were in charge of the commercial activities during the relevant occurrence period. I have not submitted any document to prove my statements made in para 4 of my evidence. The furniture, fixtures, crockery, fridges, electrical fittings and equipments for use in the space provided to the plaintiff were not provided by AAI, and these items are to be arranged by licensee, and the plaintiff himself had arranged for the same in the space. Well, these items, I by my letter requested to the airport authority to allow me to remove these because my agreement was cancelled. And thereafter, I request them that at least you allow me to get these items removed from the space, and thereafter I will hand over the space to you. They acceded to my request, said that you can. But whenever I happen to visit the airport, since my entry, my and my employee entry passes were cancelled, I was not allowed to enter the airport terminal. But without entry pass, I cannot enter. And these items were within the AAI premises. So whenever my staff happened to visit there to remove the things, item to take back the item, they were not allowed to inside. And this in a series of letters I requested them, but all the time they say that they have not done that, they have not done that. You say you send this time, like that. They repeated to give me time and time, but whenever I visit, they did not allow me to enter. And in the WS, they denied. They stated that these items were not given by me, but their witness himself says that AAI is not giving any such item, and this is to be arranged by the licensee and done by the it is of the plaintiff himself. Plaintiff himself had arranged for the same in the space. I cannot say about the expenditure incurred by the plaintiff in arranging and installing aforesaid items for use in the space provided by AAI, and I have no estimates about the expenditures of the plaintiff. I have not given any explanation as to on what basis I have denied the investment of the plaintiff to the tune of 26,12,254. I have no knowledge as to whether the plaintiff was given open space or covered space for use of the space in the name and style as sweet and salty parlor. Because in the WS stated that I have not constructed the space and these things. It is not a fact that the statements made in para 4 of my affidavit are false. I have not submitted the reply of the plaintiff referred in para 5 of plaintiff's evidence along with my evidence on affidavit. I have not filed the letter dated 22/4/2008 of the plaintiff with my affidavit to show that same was received by AI on 24/4/2008. I cannot say as to by what mode Exhibit 11, that is letter dated 7/5/2008, was served on the plaintiff. But their Exhibit 11, actually, they intended to say that by their letter 7/5/18, I was asked to remove my belongings from the premises, but that letter was never given to me. I cannot say if airport restaurant and also allotted to and operated by the plaintiff. I admit that the plaintiff had letter dated 8/5/2008 had informed the AAI, airport director of LGBI, what is that the letter dated 22/4/8 is in respect of airport restaurant and not in respect of sweet and salty parlor. The said letter was received by AAI on 9/5/8. I cannot say whether plaintiff has requested seeking permission to him or to his staff for removal of his belongings from the premises on 16th and 17th May on the basis of plaintiff Exhibit 14 without comparing from my copy of the document. Further cross. In para 5 of my affidavit, I have not given any explanation regarding evasive and unsatisfactory reply of the plaintiff in respect of bank guarantee. Along with Exhibit 11, I have not submitted any proof of delivery or mode of delivery of Exhibit 11 to the plaintiff. It is not a fact that Exhibit 11 was not served on the plaintiff. It is not a fact that contents of para 7 and 8 of my evidence and affidavit are not correct. It is also not a fact that plaintiff had taken steps for collection of his belongings and had sent his man, Mr. Ranjit Mandal, to collect belongings, and AI did not allow to collect the belongings. It is not a fact that the contents of para 9 of my affidavit is not correct and that the termination of contract with order dated 25/4/8 was violative of the terms of contract. It is not a fact that the plaintiff's contract was illegally terminated and rules and terms of contract were not followed. I have no knowledge as to the result of the FIR lodged by airport director against the plaintiff. My statement has not been recorded by the police in connection with the said FIR. It is not a fact that the allegations I have raised in para 10 of my affidavit are not correct. does not affect that the bank guarantee furnished by the plaintiff was not fact. I have no knowledge about any court verdict concerning the genuinity or validity of the bank guarantee. Does not affect that the acts of the AAI in blacklisting the plaintiff in absence of any court verdict concerning genuinity and ability of bank guarantee were illegal, arbitrary, and unauthorized. It is not a fact that the plaintiff is falsely and unreasonably blacklisted. It is not a fact that for the aforesaid acts of AI, the plaintiff is entitled to rupees so and so, along with interest and cost and as paid for. I cannot say now as to whether the plaintiff was asked to take his belongings from AI campus after instead of this studio. My lord, they have also taken a plea that in my plaint, there is no prayer for recovery of my belongings. To that effect, Your Honor, in para, kindly see page number. The serial page number 31 of the RFA. That is a copy of my plaint. A schedule. Page 31 of our serial page of my RFA.
Yes.
Schedule A. Since the AAI has not allowed the plaintiff to remove his belongings, structures, furniture, utensils, crockery, equipment, electrical and electronic items, etc., and has kept the same illegally and thereby rendered the same useless by its non-use and has also imperiled the value the same as such plaintiff claims the value the same as well as refund of security deposit from the AAI, the part of which are as follows. These are. Last item is security deposit of 348,842. My lord, in exhibit 1, Your Honor, there are two securities. One is to furnish by way of bank guarantee, that is over 34,08,000 something. And another is electricity security deposit, that is 3,40,842. Exhibit 1, or clause number 8 at page number 2 of exhibit 1. Security deposit for electricity. An amount of rupees 340,842 has to be deposited as security deposit for electric connection within 15 days from the date of issue of this letter in the form of DD payable to AI Guwahati. And this is paid to them. And therefore not disputed by them. So this and the other amounts claimed against the structural fixtures, furniture, crockery, and this. And DW1 in his cross-examination has stated that the AI has not provided these items, and these items are to be arranged by the plaintiff himself. Moreover, in exhibit 1, Your Honor, it is clearly mentioned that clause 5, exhibit 1, is space rental. A space measuring 14.5 square meter in central concourse area shall be provided by AI, for which you have to pay space rental of so and so per month in addition to the electricity, water, and conservation charges, which are subject to revision from time to time. Clause 6. Security deposit is to be, that is 34,08,420, and this was furnished by a bank guarantee, which AI says that this bank guarantee is fake. So there are two security and 8 is security deposit of electricity. And in so as per exhibit 1 also, only space has been provided to me, not any constructed premises. So their contention that I have not paid for return of my articles, my lord, that does not mean that since I have already stated in my plan that the value of those items are already impaired and these have become useless. I mean, because of non-use, because of not allowing me to obtain these items. So I claim the value of that. And in the WS, my lord, they have noticed there is no whisper as to where these items are. Even there is no any counterclaim by them or is the rentals if the items are not removed by me. they themselves, because when the contract was cancelled, by that time itself, they had put lock on the premises and I was not allowed to open it. Whenever my persons visited there, they were not allowed to enter to take the belongings. So premises was all along under their possession, under their control. And the W, they are completely silent about the lock and as to why, as to where those items are now. That way they misapproved those items. Even if I am blacklisted, that blacklisting period is already over, but security deposit of 3 lakh 40 of electricity security and the value of these items, furniture, fixtures, crockery, AC and these things, they are liable to pay. The landed court below had altogether framed 10 issues. Out of that, issues number 1 to 7 23 page number, serial page 53 of the RFA. Those are the part of the judgment issues where page number 53. So I am agreed by the findings on issues number 7, 8, 9, and 10. Issues number 7, 8, 9, and 10. Findings on issues number 7 and 8 is at page number 56 of the serial page 56 of the RFA. The landed court below has held that the actions of the AAI in blacklisting me by saying on the ground that the bank is on the ground of the conversation between the bank and AI, wherein the bank has said that these are fact, but there is no any court vetting to that. And as regards 9 and 10, my lord, on the basis of findings arrived at on 7 and 8, it is held that I am not entitled to any of the release, my lord. At least, my lord, my security deposit of 3 lakh at least security and my value of the items which I have invested, that is crockery and these things, that I am entitled.
So how the learned trial court has dealt with that issues?
7, 8, 9, 10. Trial court has held that since I have not made any specific prayer for return of the goods, and trial court has stated that till now I have not handed over the space to the AAI. But the space is no more there. When the suit was filed prior to that, that itself it was removed. The belonging, my belongings were no more at the place. And where the AI, what did the AI did of my thought belonging is not in. This is specified in the WS. There is no counterclaim also by the AI. If the any loss is caused to the AI by not removal or by not handing over the premises to them, they have not claimed any rental from me also. That itself means that they have already removed my articles. Exhibit one clause 20 also speaks that licensee shall construct the partition on the premises at his own cost, but in accordance with the size and design approved by the authority. So the premises, my premises perspective study is made by me. At my cost and expenditure. Premises were put on under law on 25/4/8.
Yes,
That's all. So being agreed by that input findings, rejecting my claim, I prefer this second my lord. Because I am not allowed my security deposit of electricity, they have not been released, and I am not allowed to, I was not allowed to remove my belongings, and for that I sustained loss.
yes, Mr. Dubey.
Make this lordship. I'm just a person on the blood. Can I make one prayer, Lord? If your lordship can take it up for my response at 2 p.m. Lord. I will have
No,
to show
2 p.m. we have other matters also.
Because
Why at 2 p.m.?
Lord, just I'll, the entire evidence is not with me, so I want to go through the record.
Evidence I can furnish you, I can give.
Yes, so I'll need to have some. I will not make much longer.
Okay.
Yeah, possible.
Okay. Item 18.
May I please your lordship, I am appearing for the respondent in the appeal, then appeal was listed at the request of my learned senior. Lordship, today I have some personal difficulty. May I pray for adjustment of the day, lordship? Any date in the next week?
Yes,
Only for that day, lord.
2018 matter, my lord.
I understand,
Lordship
lord.
may fix a short date, maybe in the next Tuesday.
next Tuesday, before vacation may not be possible because we have already fixed a lot
Friday,
of
ma'am.
cases.
Friday is possible.
Lordship, I don't.
Before vacation, we are unable to accommodate you.
Very short matter, my lord. If she has difficulty, what can I say, my lord? It's 2018 matter.
Lordship, actually.
Very short matter, my lord.
Can we fix on 24th?
My lord,
24th of September,
23rd of September.
24th.
Tuesday. Yes, yes. Yes, yes.
Okay. Art, madam, your good name?
Embora.
Embora. On the request being made by Ms. Embora, learned counsel for the respondent, having not been objected by Mr. Sorma, learned counsel for the appellant rests shall list the matter on 24th of September.
Item 19.
So this revision is against the to put the concurrent judgment of the trial court as well as the first appellate court. I'm alleging the perversity as well apart from the other grounds. Here, I was the defendant, the plaintiff filed the suit. I was stating earlier that since 1973, I have been occupying the suit premises as a tenant. Initially at a monthly rent of rupees 150, with a stipulation that within the 15th day of the month, the rent will be paid. And subsequently, the rent has been enhanced from time to time. And since the beginning, I have been defaulting in payment of the rent. Sometime I pay in lump sum, sometime after a year, sometimes 6 months, etc. And since January 2000, though the rent was fixed at rupees 450, unilaterally the defendant, that is the present petitioner, has been paying rent at the rate of rupees 350 per month, that to 3 months together. So thereby, my lord, claim for my ejectment as well as the arrear rent since January 2000 till the date of realization, etc. I have submitted my the written statement. I said though the agreement was of 1973 for a period of 11 months at a consideration of rupees 150, but subsequently on mutual agreement, the rent has been paid in lump sum, sometime 6 months, sometime in advance, and sometime in consideration of the services that I render. I am an electrician by profession, so I used to be doing the electrical works in the premises of the plaintiff, so that amount is also adjusted. And since December 2001, I have been paying the rent 3 months together. 1 month when it fallen due and 2 months in advance. And that way I kept paying up to the May 2006. And thereafter, the plaintiff having refused to receive the rent, I have been paying the same amount in the court. Now the issues were framed. The trial court has found that although it has considered the date of due date of payment of rent was on the 15th day, but with the conduct of the parties and due to acceptance of the rent at different intervals, so that was accepted. However, found that since August 2008, I have defaulted in payment solely on the ground that the section 5(4) that was not complied with.
Section
5(4) of the Act, that tendering the amount. And the appellate court, in a very summarizing conjecture, though formulated the point for decision, but it did not pronounce any order in the issue wise. And it has concurred with the judgment of the trial court, only differing to the extent that the default was from May 2009, June-May 2009. And therefore, I am a defaulter. So far as the other ground that has been taken is with regard to the bona fide requirement. It is just simply in the plain, it had been said that for her business accommodation, the plaintiff's business accommodation, the plaintiff requires the premises I have been occupying. And in written statement, I have given an elaborate description of the property, including in the place, in the area where the suit premises is situated, there are about more than 8 bighas of land. And therefore, it is only for the eviction of the tenant such plea has been taken. There was no other explanation or further elaboration how the suit premises is required for her business expansion, or that she has taken any steps towards bona fide use of the land. That has not been given. But during the course of evidence, she has produced the
permission from the Dibrugarh Municipal Authority as well as Development Authority. That under objection because there was no plea in the plaint to that effect, nor it was my lord, the leave of the court was taken, nor it was my lord, in the list of my lord, documents submitted by her. Notwithstanding that, solely relying on the judgment of the Supreme Court that it is the landlord's prerogative in what way the suit premises is required. On that basis, my lord, the judgment on that count also, bona fide required was my lord, held to be my lord, proved. But the number of judgments I have also relied on along with my the appeal memo. I have mentioned there also. None of those have been discussed. So against this judgment, the appellate judgment, affirming the judgment of the trial court, I am preferring this. Lordship, come to the plaint. One thing, if the other side agrees on the point of that the decision on all the issues were not given under this order 41 rule 31. The matter can be remanded, or otherwise, on merit it can be subject to what my friend says.
Order. You are referring to order?
Order 41.
Rule
31. Although it has not specifically said that on each issues the decision has to be rendered, but the various judgment of the apex court as well as of this court, it has been said that point for determination method in each of the issues, the appellate court has to pronounce its judgment. More particularly, the discussion with regard to the point where it differs with the judgment of the decision of the trial court. So that is one of the ground method. And otherwise, on the merit, if you look see the plaint method to understand the content method. The plaint method. At page 19.
Yes.
Starts from page 21. The defendant, Sri Govardhan Prasad Modi, son of Sadayalal Modi, having amongst others the business of Modi Electrical Works at Koil Road, New Market, Dibrugarh, Assam by professional electrical supervisor, has come to occupy the premises more fully described in the Schedule A here to below as a monthly tenant under the plaintiff according to the English calendar month by agreement on 22/11/1973 with effect from 1/12/1973 for use as a residential quarter, undertaking to pay rent of ₹150 per month payable by the 15th of each succeeding month. That the premises of the plaintiff is a part of the barrack type house at Gaham Bazar, Dibrugarh town, and each of the premises in the said barrack type rented premises of the plaintiff are having independent tube wells and separate latrine and bathroom. The said premises is a CIC roof Pakka house consisting of 6 rooms with kitchen and bathroom standing on a part of the land covered by DAG number 27 of PP number 66 of Dibrugarh town Moja and a part of municipal holding number 3. New 325 old. These premises being the subject matter of the instant suit, hereinafter referred to as the suit premises. That the defendant failed to conform to the terms and conditions of monthly tenant and as a very irregular in paying his said monthly rent from the beginning and is a defaulter in payment of the monthly rent every month and has thereby rendered himself a defaulter. In spite of objection and remedies by the reminders by the plaintiff, he has still date paid his monthly rent as per his own choice, refusing to abide by his own amicable settlement to raise the said amount rent to rupees 450 per month since January 2000. That the plaintiff sent a notice by registered acknowledgement due to a due post through their advocate on 11th February 1980, to which this defendant sent his reply on 29th February 1980, admitting his default and promising to pay the arrear rent by the first week of April 1980. But the defendant did not do so, and the defendant paid his defaulted arrear monthly rent on 1/4/1988. That even after his said written commitment, the defendant failed to pay his arrear rent, and the plaintiff had to send on 29th January 1993 another demand to clear his arrear monthly rent since July 1991, which was received by him on 29th January 1993, and thereafter he ultimately paid his defaulted arrear amount on 27/3/1994. That the defendant again defaulted to pay the monthly rent and was asked to pay his arrear rent and refrained from defaulting and making part payment of his monthly rent by plaintiff's letter dated 21/6/2001 by registered acknowledgement post terminating the tenancy and asking to vacate the suit premises with effect from 31/7/2001, to which he sent his reply making various false statements on 9/7/2001, which was immediately clarified by plaintiff's registered letter dated 14/7/2001. That since the defendant failed and neglected to renew his tenancy agreement since 31/10/1974, but however he by mutual agreement with the plaintiff increased the monthly rent at the rate of rupees 100 per month at various intervals, and accordingly the monthly house rent, which was fixed at rupees 150 from December 1973, was increased to rupees 250 per month from April 1988. Then again, the same was increased to rupees 350 per month from April 94. And then he again agreed to increase the said rent of rupees 450 per month from January 2000. That as per mutual agreement between the plaintiff and the defendant, it was further agreed to renew the deed of monthly house rent agreement dated 22/11/1973 in 2000 itself. That on receipt of the letter dated 15/1/2002, the defendant sent a reply on 3/2/2002, falsely claiming that he has never defaulted, which was immediately replied to by the plaintiff who had registered letter dated 12/2/2002. That the defendant sometime in April 2004 illegally extended the suit premises with a room covering the backside veranda of the rented house without any knowledge and permission of the plaintiff, and raised a water tank with RCC structure. That in spite of the reminders, the defendant continued to be a defaulter, and the plaintiff asked the defendant to make payment of all arrear rent and remove his illegal construction on the back veranda at the vacant space at back of the said suit premises, and raised pakka structure by plaintiff's various letter being letter number and that as follows. That in spite of such objection, the defendant did not demolish his said illegal construction and extension and obstructing the plaintiff and their man to enter into the suit premises to check the said premises, causing destruction and damage to the suit premises and encroach the backside veranda and vacant land of plaintiff. That in the last week, the plaintiff saw some split bamboo wall room with the roof constructed on the front side vacant land of the plaintiff in front of the suit premises, which is more fully described in the schedule B here to below, occupying and obstructing the vacant area by the defendant, causing loss and damage to the suit premises owned by the plaintiff. That the defendant to pay the balance area rent of rupees 7,700 being the balance payable since he agreed to raise monthly rent with effect from January 2000. The plaintiff in bona fide good faith adjusted all subsequent house rent paid by him as part payment up to January 2005. And as such, the defendant is to pay an outstanding rent of rupees 7,700 up to April 2006. The plaintiff has also claimed compensation of rupees 5,000 for illegal construction and damage to suit premises and mensa profit of rupees 450 per month from the date of filing of the instant suit for the illegal unauthorized use of the suit premises. That the plaintiff also bona fide requests the suit premises for their own use, as the plaintiff is facing hardship in providing accommodation of its own business need. That the defendant being a defaulter and enforcement of the suit premises is an undesirable tenant causing irreparable loss and damage to the plaintiff premises. That the
Okay, three more paragraphs are there. Let us complete it.
Lordship, that the plaintiff accordingly claimed the first possession of the suit premises by ejecting the defendant therefrom describing in schedule below, and also claims rupees 7,700 as area rent and rupees 5,000 as compensation and mensa profit. The plaintiff also prays for grant of mandatory injunction for demolishing all illegal and unauthorized structure raised by the defendant in the suit premises. That the cause of action of the suit premises arose on so and so date. Then for the purpose of court fee, etc. So they were paid for page 28 for first possession of the said premises by evicting the defendant, his employee, and then recovery of rupees 7,700 and mensa profit of rupees 700. That is the basically although it has been said since 1973, after entering into the agreement, I was defaulting and there's no agreement, but it is also an admitted fact that at different interval of time, different point of time, both the parties has agreed to the increase rent, and accordingly that had been paid. Although there is no existence, and it is also admitted that I was since beginning I have been defaulter and I used to be paying sometime after a year or so of at a lump sum in that manner. Only her grievance, what it appears from the plain, is that since 2000, though the payment was enhanced to 450, I have been unilaterally paying rupees 350 per month, and therefore she is claiming me to be a defaulter with effect from that day, and the area rent of rupees 7,700 from January 2000. That is what the plain reveals. Now,
So if you were admitting that you were defaulter, then where is your case?
Those are earlier. Thereafter also, on mutual agreement, that was what is said is 1980. Thereafter also, on mutual agreement, the rent was fixed. We have been paying, though there is no written agreement, and she has been accepting. Her whole grievance appears to be that in January 2000, though the amount rent was fixed rupees 450, I have been unilaterally paying rupees 350. So therefore, she is seeking this area rent for this from January 2000. Now, there may be an agreement, there may be a due date, but if the conduct of the parties, both the parties, the tenant tenders and the landlord receives, that a new condition, notwithstanding the written condition in the agreement, that comes into existence, because it is between the landlord and the tenant. Since from the written, that was for initial agreement, they have deferred to that. She has accepted the rent in lump sum. She has also increased the rent from time to time, and I have been agreeing to pay. The new conditions comes, and the court also to that effect, the finding of the both the courts are also there. Although there was a stipulated condition, but by the conduct of the parties and they have been receiving, so there is no default on that count. What the trial court has said, that 2008 June, July also, section 5(4) that when she refuses, I have to tender the rent, and then only I am entitled to deposit in the court. So that part is not there, that tendering part is not there, or refusal part is not there. So therefore, the trial court has held me defaulter from August 2008, September 2008. Not beyond that. During the continuation of the proceeding in 2008, there was a default according to the trial court that I did not tender and I have directly deposited. So therefore, from that day, I have been declared as a defaulter. And the appellate court has found me the defaulter May 2009.
So trial court found you defaulter with effect from?
From September 2008.
And the appellate court?
Found from May 2009. And the ground of the appellate court of relying on the, why June 2008 could not be accepted, the finding of the trial court of that I have defaulted in 2008 is not been discussed. But the new date has been assigned because there are some overwriting in the notice that I had sent to her before depositing the amount. That is the reason, without giving me any opportunity to explain that, my lord. It is the duty of the plaintiff to bring the record of the rent cases to show that even during the proceeding, the defendant has defaulted in payment. That has not been done. The court has called for the things, and having found that in one of this particular notice, there's some overwriting. So therefore, the court has held that I'm a
Okay.
defaulter.
We will resume at 2.
Lordship.
Yes, who is your leading counsel?
My lord, I will.
You will. So he has offered one proposal.
No, my lord, we are objecting to that because in my humble submission, the learned trial court has decided. on
Rightly
it.
decided. Okay.
But I'm praying for your lordship's intelligence, but I have taken the consent of my friend who was on legs. But as regard item 17 minutes, some there difficulty, but I have taken the assistance of my friend for getting some of the documents which he has allowed me. I pray that matter will be taking some time later on. Since your lordship has already heard my senior friend, let it be kept partner also, but I'll make my submission.
When?
As per your lordship's convenience, madam.
After long vacation.
That would be again, madam. Can I try first week of
Before
October? at least?
vacation, we are
It is
unable to
already
accommodate
parted
you.
in this week itself, if possible.
So many cases. We will not reach there.
I have already concluded my part, but only my.
After vacation.
Immediately on 22nd October.
Heard Mr. Morzia, learned counsel for the appellant. And also heard Mr. Dubey, learned counsel for the respondent. List the matter on when?
22nd October.
22nd October
22nd.
as part heard.
22nd.
Yes.
Now the written statement, madam. The statement is at page 31. May I skip this initial part? Page 33, paragraph 18 onwards.
Yes.
Paragraph 18. That with respect to the statement made in paragraph 2 of the plaint, it is submitted that the defendant came to occupy both the suit premises described in the schedule A and B of the plaint, agreeing to pay the rent by 15th of succeeding month. But since the inception of the tenancy, paid the same as per his convenience and suitability, sometime monthly and sometime for some months together in lump sum, which the plaintiff always accepted without any claim, demand, or objection thereto. That the defendant is an electric supervisor by profession and used to render his services to the plaintiff from time to time against the charges to be paid or adjusted against due rent. The plaintiff is not in a habit of granting any receipt of the said rent paid to the plaintiff, and as such, the defendant used to record such payment made by him in cash in his cash book. The plaintiff, via this letter dated 4/3/1997, demanded payment of a sum of rupees 4,800 against rent since July 74 to February 1977 at the rate of 150 per month, and on payment of a sum of rupees 2,311.65, and on adjustment of BL of bill amount of rupees 2,188.35 against service rendered by the defendant, squared up the account of rent up to December 1976. Copy of the said letter and the statement of account of rent up to December 1976 are filed herewith and marked as a defendant document number 1 and 2 respectively. The plaintiff then by his lawyer Still and Hado notice dated 11/2/80 terminated the tenancy of the defendant with effect from 1/3/1980. The defendant has since then been occupying the rent suite premises allegedly as trespasser and not as tenant. The defendant files here with a copy of the said notice so and so marked as so and so that the compensation rent was enhanced from time to time from rupees 150 to 170 and then rupees 250 and then finally to rupees 350 per month. That the defendant paid to the plaintiff a sum of rupees 1360 on so and so at different dates to show that it is paid in lump sum. Then 18.8. That the plaintiff since January 2000 on his own enhanced rent.
Whether this claim is supported by any documentary
Documents.
evidence?
Yes, my lord. My cash book, etc. These have been exhibited. She has also exhibited the ledger, more particularly exhibit 7, 8, 9. Therefrom, it clearly appears that the rents are accepted in lump sum as well as my lord, the services rendered by me, the payment which the service I have rendered while it was transformed into the
That is acknowledged.
acknowledgement, that is admitted. my lord. That is in the ledger book of the plaintiff herself, 7, 8, 9. So therefore, my lord, the trial court did not take into consideration of all this. Although it initially has fixed that 15th day of the month is the due date, but we'll go to directly to the my lord, so far as bona fide requirement, I just wanted to point out in my WS what I have said. Page 13 and paragraph 29. That the allegation made in para 16 of the plaintiff are false and denied. It is specifically denied the plaintiff bona fide requires the suit premises for their own use as the plaintiff is facing hardship and providing accommodation of its own business needs as a lease. The plaintiff has purchased 8 bigha 2 katha 8 lesa and got transferred mutated to its name a total plot of land measuring 8 bigha so and so in different DAG number. Gaham Bazaar Ward, Dibrugarh Town Moja on a part of which some houses including the suit premises are standing. The plaintiff has not shown as to why the suit premises then the other house of its Alice bona fide requirement is preferred. The plaintiff had 11 number of sale deeds, all dated 8/8/2002. Had also sold a total plot of land measuring 2 bigha 4 katha 0 lesa from and out of the said land measuring 8 bigha 2 katha 12 lesa. Well, the total land was 8 bigha 2 katha 18 lesa, where the house is also situated. She has just in 2002 sold out about 2 bighas and all. It is also submitted that the plaintiff in the year 2000 leased out the premises earlier occupied by Messrs. Jain Hotel and Restaurant and against whom an ejectment suit was filed to one Madhav Borua by registered deed of lease on rent. It is further submitted that plaintiff has very recently got one house vacated by the side of Messrs. Jain Hotel on HS Road, Dibrugarh, and in that view of the matter, the claim of the bona fide requirement is not sustainable in law and on facts. It is also submitted that the plaintiff has also been permitted by the Honorable High Court to construct a multi-story building in the place of the shop premises let out to Hanuman Bagh Sagarwala, since this is on the southern side of the said Jain Hotel and Restaurant. His need for the suit premises is therefore not genuine, honest, and bona fide. Detailed particulars, everything I have given. 30.1 is specifically denied that the defendant being a defaulter and encroacher of the suit premises and undesirable tenant causing irreparable loss and damage to the place. Now, my lord, the evidence have been laid. In the evidence, my evidence, my lord, I have clearly stated that successively rent was tendered to the my lord, plaintiff, and on being refusal, I have deposited. That I'll bring to your lordship notice, my lord, in the subsequent states. My lord, the trial court judgment at page 45 issues of my lord, page 47.
Yes.
That's my lord, here as many as 5 issues are there, but these 3, 4, and 5 will be relevant. But the decision in my lord, issue number 3 at page 15. Whether defendant is a defaulter in payment of monthly rent, whether the suit premises is bona fide required by the plaintiff, whether the plaintiff is entitled to relief as per. Now, issue number decision and issue number 3 at page 50 Paragraph 12. Paragraph 13, my lord. The plaintiff has taken the plea that the defendant is a defaulter in respect of the payment of rent in order to adjudicate it upon the issue of defaulter. The first important question which need to be ascertained as to when does the rent fall due. I'll read it again, Miller. The plaintiff has taken the plea that defendant is a defaulter in respect to the payment of rent. In order to adjudicate upon the issue of defaulter, the first important question which need to be ascertained as to when does the rent fall due. That is very important, Miller. The plaintiff contended as per the rent agreement between the plaintiff and the defendant, which is exhibited as exhibit number 2 dated 22/11/1973, the rent of the defendant falls due on the 15th each succeeding month. The learned counsel for the defendant vehemently submitted that the exhibit cannot be considered in evidence as the same is not registered and therefore does not comply the statutory mandate of Section 17 of the Indian Registration Act. Section 17 of the Indian Registration Act requires the rent agreement made for a period of 1 year or more to be compulsorily registered. However, it is seen that Exhibit 2 was made for a period of 11 months only, and thus registration of the said agreement is not mandatory. Exhibit 2 clearly indicates that the tenant agreed to pay rent at the rate of rupees 150 per month by the 15th of the succeeding month. Thus, from Exhibit 2, it is apparent that rent fell due on 15th of each succeeding month. Thus, as per Section 5(1)(e) and Section 5(4), the time of payment of rent to the landlord or for depositing in court, it is a fortnight from the date on which the rent fall due. It is also admitted by the defendant in his written statement that he had agreed to pay the rent by 15th day of each succeeding month. Thus, the rent had to be paid within a fortnight from the 15th of each succeeding month. But this is confining to the finding of the agreement. The subsequent event will follow now. The plaintiff claims that the defendant is a habitual defender. The defendant, on the other hand, contended that he had always paid the rent for a few months together in lump sum, and the plaintiff had accepted the same without any claim or objection. The rent was admittedly increased to rupees 350 from April 94. The plaintiff alleged that the rent was mutually agreed and then enhanced to rupees 450 per month from January 2000, but the defendant contended that the rent was unilaterally enhanced by the plaintiff without the consent of the defendant. Exhibit 7, 8, 9, 10, 11, 10A, 10B, 10C, Exhibit 11 to 66 shows clearly that the rent was paid by the defendant for months together and not every month by 15th of the succeeding month when the rent fell due. These all exhibits are of the plaintiff. Exhibit 67 indicates that the plaintiff had sent a notice to the defendant asking him to vacate as he had failed to pay rent from March 1978 onwards and thus branding him as a defaulter. The defendant, via Exhibit 68, admitted the default for rent for the March 1978 till March 1980 and promised to pay it by the first week of April 1980. Exhibit 7 last entry shows payment of the rent from March 1978 to February 1979 on 29 to 1980. Exhibit 8 shows the rent of March 1979 to December 1987 was paid on 1/4/1988. Thereafter, the plaintiff had Exhibit 69 dated 29/1/1993 again sent a notice to the defendant to pay the arrear of rent due to the plaintiff from July 1991 to January 1993, and the defendant paid the arrear at the rate of 250 per month as rent from July 1991 to March 1994 on 27/3/1974 as appeared from Exhibit 8. The full bench of the High Court, Assam and Nagaland in Kali Kumar Sen versus Makhanlal Biswas, AR 1969 and 66 had summarized the legal position as to who was a defaulter, wherein it was held that if the rent is tendered or deposited beyond time and the same is accepted by the landlord, then the tenant cannot be evicted. In the instance of the plaintiff contends that the rent was enhanced from rupees 450 per month with effect from January 2000, but the defendant alleged continued to pay the rent at the rate of 350 per month. The defendant contends that the rent was unilaterally enhanced by the plaintiff landlord without the consent of the defendant. The learned counsel for the defendant cited few rulings of various high courts where it was held that unilateral enhancement of rent cannot be termed as agreed rent. The plaintiff had by Exhibit 70 dated 21/6/2001 informed the defendant that the defendant has not paying the full rent at the rate of 450 per month, and the rent paid by the defendant has been adjusted as part payment. Exhibit 71, Exhibit K, dated 9/7/2001, is the reply of the defendant to Exhibit 70, wherein he had denied that the rent was mutually enhanced to rupees 450. There is, however, absence of any evidence or oral or documentary as to the mutual enhancement of rent to rupees 450 per month since January 2000. Unilateral enhancement of rent cannot be said to be agreed rent. The Exhibit 2429 are rent receipt filed by the plaintiff, which indicates rent for the month of January, February, March, April, May, and June at the rate of 350. Exhibit 30 is the rent receipt, which indicates the amount of rupees 350 received from the defendant as area of January, February, March, which indicates part of March. There are various communications between the plaintiff and the defendant which have been exhibited, and it appears that the rent paid by the defendant to the plaintiff beyond time in lump sum was accepted by the landlord plaintiff, and the amount of rupees 350 per month as per rent paid by the defendant was accepted by the plaintiff, and the same was adjusted as part payment. Exhibit 91 shows that the defendant had paid the house rent up to March 2005, but the plaintiff had asked the defendant to pay the defaulter arrear of monthly house rent and to remove the illegal construction. Exhibit 95 indicates that the house rent was paid by the defendant up to part of June 2005, and the same tallies with Exhibit 10C, though it appears that the plaintiff opposed to mode of payment by the defendant of rent of 3 months together, but it appears that the lump sum area amount was, in spite of protest, accepted by the plaintiff landlord. The defendant has sent rent up to May 2008 through banker check. The defendant in his evidence submitted that the plaintiff refused to accept the rent for the month of June 2008 to August 2008 when sent to it through registered AD post white banker check number banker check dated 24/6/2008 for rupees 1050, and so the defendant since September 2008 had to then deposit the rent in court by miscase number so and so. Section 5(4) of the Assam Urban Area Rent Control Act lays down the tender offer of rent of the landlord before deposit in court and the subsequent refusal by the landlord to accept the same as a statutory prerequisite. The tenant must establish that he had tendered the rent to the landlord and the landlord had refused to accept the same. The burden of proving that he is not a defaulter lies on the tenant. Thus, if the same cannot be established by the tenant, deposit in rent in court shall not be considered to be valid deposit. In the instance, so DW1 in his cross-examination testifies his tendering of rent on 24/6/2008 was not accepted by the plaintiff, as the rent was as per plaintiff, not according to the agreement. Thereafter, he testifies that since then he had been depositing the rent in the court, but nothing could be brought forth to establish the proof and tendering of the rent to the plaintiff every month, and in subsequent refusal to accept the rent before depositing it in the court. DW1 in his cross-examination testified after he had started depositing the rent in court, he never approached the plaintiff or offered any banker check to him every month before the deposit of court. Moreover, there appears nothing on record that the relationship between the landlord and the tenant were extremely strained. Thus, it cannot be said that the deposit of rent made in the court are valid. Now, pausing for a moment, if your lordship looks into my affidavit, the evidence on affidavit, specifically, my lord, separately, I have submitted this evidence on 26/9/2018 because the records were not very legible. So, my lord, I have submitted a separate bunch, my lord, of the evidences. As you also got the bunch, my lord, I have filed separately. Well, in page 59 in this bunch. Yes. It's the same evidence what is on the record, but these are legible copies. Page 59. I'll directly, my lord, page 61, paragraph 16. Page 61, paragraph 16. That the defendant since September 2008 started offering tendering rent in cash and on refusal thereof by the plaintiff to accept, started depositing the same regularly in court and on such successive refusal have deposited the same up to May 2012. So this has specifically said that on every successive tendering, he has deposited the rent in the court. So this, the finding of the trial court is that there's nothing on the record to show that I have tendered. So this is, this has not been cross-examined, nor any variation has been found on this point. Now, coming back to the judgment, the Honorable High Court in Devkinandan, Bajaj and others versus Luku Burman and others held that deposit of rent without offering to landlord and where there is no whisper to prior offer of rent and refusal the deposit of rent is non-est in law, being derogation of section 5(4) of the Assam Urban Area Rent Control Act 1972. Thus, since the rent has not deposited in terms of section 5(4) of the AURAC, it cannot be said that the tenant has paid rent since June 2008 and thus tenant is a defaulter. So that is the finding, that I am a defaulter from June 2008. Now issue number 4, paragraph 16. Whether the suit premises is bona fide required by the plaintiff. The plaintiff contended that the suit premises is bona fide required by the company for own business and is some construction. And for some construction, the plaintiff has right exhibit 97 and 98 obtained necessary permission of the said construction. The plaintiff further contended that the premises is in a condition which requires repair. It is well settled proposition of law laid down by the Honorable Supreme Court in Raghavendra Kumar versus Farm Frame Machinery and Company AR 2000, Supreme Court 534. That the landlord is the best judge of the requirement and he has got complete freedom in the matter. But these two exhibit 97 and 98, but these are of 2005. It was neither mentioned in the plaint that he has obtained permission, nor the leave of the court was obtained to exhibit these documents.
97 and 98.
97 and 98. The defendant has submitted that the plaintiff has various other lands and premises which may be put to use by the plaintiff rather than the said suit premises. The learned counsel for the defendant submitted that the requirement of the plaintiff has to be genuine and honest. In such a case of the Honorable Supreme Court in the said Nagi Purushottam versus Himalbhai Prabhutal 2005 8 SSC 252, that it is the prerogative of the landlord, and if he requests the premises in question for his bona fide use of the expansion of business, there is no ground to say that the landlord already that his business and therefore it is not genuine need. In view of the said precedent and considering the oral as well as documentary evidence laid down by the plaintiff pertaining to the requirement of the suit premises for construction of business need by it, can very well be said that the suit premises is bona fide required by the plaintiff. In this particular case, this Raghavendra Kumar, which has been relied and followed by the subsequent, their specific case was that though there are several numbers of shop, but this particular shop is suitable for me, and the rest all are under occupation. All the shop premises are under occupation, but this particular shop is suitable for me. So the specific, he said that this particular premises is suitable for. So on that ground, the proposition laid down by the Honorable Affairs Court will not be here, because in the plaint, it just simply said just to accommodate his business or accommodate his persons, nothing elaborately why this particular premises was required, my lord. It is not there. Then, my lord, issue number 5.
No, apart from that averment, whether further averment is necessary.
Lordship, madam. Yes, madam, that is there, madam. That it is honest and genuine. It has to be given.
Hmm.
2005 document, what was in his possession? Would have said, I have already obtained the permission and I require this bona fide because of this. Permission definitely would have, my lord, accompanied with the plan of the building or the houses or the business premises, etc. And 2005, definitely in that case, it could have been said, but nothing has been mentioned there. Nor leave of the court has been obtained to, my lord, exhibit those documents. Then issue number 5, whether the plaintiff is entitled to relief as prayed for. 19, from the discussion above, even though the plaintiff contended that tenant defendant had defaulted in payment of area rent for 77 months, that is from January 2005, but the documentary evidence and oral evidence suggests that the landlord had accepted the rent even after the said date on being tendered by the defendant to him in lump sum. The plaintiff has, however, contended that the said rent was adjusted as a part of the part payment against the mutually enhanced rent of rupees 450 per month, but the plaintiff could not establish by means of evidence, oral or documentary, that the rent was mutually enhanced to rupees 450 since January 2000. It is apparent that even after the payment of rent at the rate of rupees 350 as a part payment, so it is apparent that even after that, the payment of rent at rupees 350 as part payment, in the event of failure of the plaintiff to establish that the rent was mutually enhanced to the rate of rupees 450 per month since January 2000, the said payment made by the defendant tenant cannot be said to be part payment. It also well-established, well-settled proposition of law under the Assam Urban Area Rent Control Act that even in the event of acceptance of rent in lump sum sent by the landlord from the tenant cannot be held as a defaulter. Thus, defaulter of area of rent from month of January 2005 could not be proved or oral or documentary evidence. The tenant since 2008 September deposited the rent in the court by various mistake cases exhibited by him. The tenant must establish that he had tendered rent to the landlord and the landlord for refusal to accept the same before doing so. The burden of proving that he is not a defaulter lies on the tenant. Thus, if the same cannot be established by the tenant, the deposit in the rent in court shall not be considered to be valid deposit. But the burden has been shifted on the tenant totally. The initial burden is on the plaintiff. No doubt the tenant has the burden, but then he has to say that this is the mode till so and so that he paid and thereafter he did not pay. That could not be charged by the plaintiff, but then burden has been shifted to the tenant that I have tendered the payment. It is seen that the defendant could not, however, establish the said tendering and refusal to the plaintiff on every month before depositing same in the court. Thus, the deposit made in the court by the tenant cannot be said to be a valid deposit in rent. This makes the tenant defaulter since June 2008, as he could not produce any evidence that the rent was tendered to the plaintiff first and the same was refused to be accepted by the plaintiff before depositing it in the court. Moreover, from the discussion in issue number 4, it is also appears that the suit premises is bona fide required by the plaintiff for its own business. The plaintiff has been granted with an order of mandatory injunction against the tenant to remove the illegal construction in Miss Appeal number so and so, which as the plaintiff Alice has not yet been followed by the defendant. This kind of legal wrong use also makes the defendant liable to be evicted. But there was no issue framed on this. And if there be any injunction order violation, the plaintiff has the option to bringing on the record by filing an appropriate application under order 39 itself. This has not been done. There is no issue, no opportunity. Then said, this is also one of the ground for which I am entitled to be evicted, which is also alien to the provisions of the act. It is only in case of bona fide requirement and the defaulter. This is absolutely perverse, my lord. Then, my lord, against that appeal was preferred, my lord. The judgment of the appellate court, your lordship will find it starts from page 65, page 67. Now, your lordship will find page 73. After reciting the facts, page 73. for making it shorter, my lord, I have not read out the earlier provisions. My lord,
Hmm.
Page 73. Point for determination, as the challenge of the appellant is on all the issues, without framing several points, the following points for determination is framed to decide the instant appeal, whether the learned trial court rightly passed the judgment and decree dated 26/11/2015 entitled suit number 40/06, or the same requires interference by this court. The challenge was on all the issues. Mr. So-and-so assisted by so-and-so lawyer
This
counsel.
point of determination is here.
Point of determination is there.
Hmm.
Challenge was on all the issues.
Hmm.
This is the whether the learned trial court rightly passed the judgment and decree dated 26/11/2015, or the same requires interference by the court.
Hmm.
So elaborate discussion to support the my lord,
Will it not cover all the issues?
this covers all the issues, but following discussion what have been made is not
Hmm.
on the issues. And so far as concurring of the finding of the trial court, there may not be my lord, elaborate discussion or a specific discussion as to why he has my lord, did not accept the particular finding of the trial court. For that, he need to give his own my lord, findings
Hmm.
for that purpose. But the discussion in all these issues has to be there, my lord. The finding of all the issues has to be there.
Hmm.
But these are the submission from paragraph 9. Then my lord, paragraph 11 comes, my lord. Discussion, decision and reasons thereof. I have heard rebel contention advanced on behalf of the parties, also perused the record. On perusal of the materials available on record and hearing the learned counsel for the parties, let me scrutinize as to whether there is anything to interfere with the judgment and decree impugn therein. But the court has to give an independent application of mine appellate court, because that is the final court of appeal and the facts and law. Now the only discussion what sought to be done, whether there is anything to request to interfere with the judgment, my lord. But the independent finding has to be there so far as the appellate court is concerned. On careful perusal of the judgment impugned, it appears that the learned trial court elaborately discussed all the material particulars in deciding the issues, and as such, in order to maintain brevity, I'll be concise only on the points raised in the appeal without making the factual aspects bulky. On perusal of exhibit 67, admitted, it appears that the plaintiff company Paragraph 13. On perusal of exhibit 67, admitted document, it appears that the plaintiff company, via its notice dated 11/2/1980, asked the defendant appellant to deliver the vacant possession of the tenanted premises with further intimation that the relationship of the landlord and the tenant would cease to operate with effect from 1/3/1980. But on perusal of exhibit 68, admitted document, it appears that the defendant appellant, via his reply to the aforesaid notice dated 29/2/1980, admitted his default in paying the monthly rent to the landlord, which promises that he clear all the area from March 79 so and so. He would pay rupees 310 onwards towards advocate fee, and if he fails to pay the said amount by the first week of April 1980, the landlord may take any action in the court of law. It is argued during the course of hearing that by virtue of that commitment and apology, the tenant was allowed to continue the tenancy. On perusal of exhibit number L, M, N, O, P, Q, R, and S, it appears that the defendant paid rent to the landlord till August 2008. Similarly, by claiming as a monthly tenant under the landlord, the Ahmed Tea Company, right, Ms. case number so and so, he deposited the rent in the court of the rent controller Dibrugarh. Whether the payment of rent is in accordance with the terms of agreement or not will be considered in the subsequent paragraph. But at this juncture, from this admitted document, it is also crystal clear that the defendant continued to occupy the tenanted premises as a tenant under the plaintiff company. That being the position, the question that the suit is barred by limitation has no force to stand in the eye of law. The learned trial court discussed the point elaborately, and I do not find anything to interfere her findings on these issues. So far as the issue of maintainability in the present form on perusal of the exhibit 1, it appears that the board of directors of Ahmed Tea Company Limited, by its resolution dated 14/8/01, unanimously resolved to institute legal proceeding against the defaulter tenants, including the present defendant, empowering all the directors individually and jointly to take necessary legal steps in this regard. It is not disputed that Mrs. Nazrana Ahmed Islam is one of the directors of the plaintiff company. Rather, in all Ms. NJ cases, the defendant himself recognized Mrs. Nazrana Ahmed Islam as a director of the plaintiff company. Mrs. Nazrana Ahmed Islam, being a director of the company, instituted the suit, including the verification and swearing of the affidavit. Order 39 Rule 1 CPC empowers such a person to represent the suit also. The learned trial court elaborately discussed on the aspect and hence conclusion that the suit is not maintainable in law. In fact, I also do not find anything to interfere on the finding. Now, so far as point of defaulter is concerned, on perusal of exhibit 68, it appears that the defendant himself admitted as a defaulter since inception. On scrutiny of the initial rent agreement marked as exhibit 2, it appears that the tenancy was a monthly one payable within 15 days of the succeeding month, although the said agreement was for 11 months with effect from 1/12/1973. Yet there is nothing on record to show that basic ingredients of component of the terms and condition of the agreement was ever changed by the parties. Now, this is absolutely perverse because subsequently all the discussion will go to show. And in fact, my lord, the appellate court also, my lord, has himself has found, my lord. In paragraph 18 of the written statement, it has skipped the paragraph 16 of my lord affidavit. My lord. In paragraph 18 of the written statement, the defendant admitted that the rent was payable by 15th of succeeding month, but since inception, he paid the rent as per his convenience, sometime monthly and sometime for months together without any objection from the landlord. From the ledger book of accounts maintained by the plaintiff company marked as exhibit 789, it appears that the defendant paid the rent sometime monthly and sometime for the months together. From exhibit 63 to 93, it appears that the landlord company raised objection on the mode of payment as well as demanded area rent from the tenant defendant. More particularly, exhibit 80 and 95 reveals that the landlord objected the mode of payment and asked the tenant to pay monthly rent every month without default. On meticulous scrutiny and as admitted by the defendant, it is seen that he failed to comply with the terms and conditions relating to payment of the monthly rent of, to the landlord, and this aspect made him clear a defaulter in payment of the rent. Malad has not taken note of the fact that Malad, due to the change in circumstances, due to the agreement by the parties, enhanced rent and mode of payment has been changed, and it is categorically the Supreme Court, which the judgment has been referred, one of the judgment has been referred by the trial court also. So that the subsequent terms and condition would be applicable. Paragraph 19. Secondly, on perusal of the entries maintained by the plaintiff company, it appears that the defendant paid the rent up to June 2005 by banker check. Although the plaintiff contended that the rent was enhanced to rupees 450 per month from January 2000, there is nothing on record to indicate that the defendant ever paid any rent at that rate. The learned trial court discussed the material produced by the parties and came to the conclusion that the defendant is a defaulter in paying the rent. I also do not find anything to interfere with her findings. That was June 2008. Thirdly, Section 5(4) of the Urban Area Rent Control Act 1972 empowers a tenant to deposit monthly rent before the court rent controller, together with the process fee for the service of notice upon the landlord. Although it was argued on behalf of the appellant that due rent was tendered and refused by the landlord, but on perusal of the Ms. case marked as Exhibit W1, it appears that the tenant defendant deposited the same before the rent controller at Dibrugarh without tendering the same. The petition under Section 5(4) of the Urban Area Rent Control Act 1972 is silent as to when the rent was tendered to the lender. From paragraph 2 of that petition, it appears that tenant allegedly tendered the rent for the month of March, April and May 2009, but the director of the company refused to accept the same, and for which by petition dated 3/4/2009, he deposited the same before the court. This is quite violation of the provision of section 5(4) of the above act in as much as rent can be deposited before the rent control within a fortnight of its becoming due. But in the instant case, the monthly rent for the month of April and May never became due as on 3/4/2009, and as such deposit cannot be treated as a deposit in the eye of law. Similar is the conduct of Ms. J case number marked as exhibit ZE and ZG. Moreover, the content of exhibit 2G is more particular. The month and date are overwritten, erased, and no explanation has been given for such overwriting, etc. by the defendant tenant. These are the materials on record, madam. There is no opportunity to explain all these things, madam. The record was called for, madam. Court presumed these have been done by me. It is a record of the court.
No, where it is presumed.
Madam, this has been taken note, my lord. In view of the discussion above, I am of the humble view to hold that the learned trial court did not commit any wrong in deciding the issue requiring any interference at this appeal. This particular, my lord, exhibit has been not taken into consideration because, my lord, the contents of the exhibit 2G is the month and date are overwritten, erased, and no explanation has been given. There ought to have been an inquiry, my lord, why the dates are not there, why my lord, who has erased it. All these things has to be there. It is a record of the court, my lord. This NG cases, my lord. And from this discussion, your lordship will find, my lord, two views have been taken by the appellate court. One is that the rent fall due by the 15th day of the month. That is one view. And secondly, it has a hold that the rent payment for the month of March, April and May 2009. But the agreement of 1973, it was only 150 rupees. There was no agreement renewed. Then at different variation, my lord, it is admitted by both the parties. And accordingly, payment has been made. In the plain, what she is saying that since January 2000, the rent was enhanced to 450, but I have unilaterally paying the rent at the rate of 350. So she is claiming the area rent for those periods, and that I am a defaulter because I did not pay the agreed amount. According to her, it should have been 450. But both the courts categorically has found that there is absolutely nothing on the record to show that unilaterally the rent was enhanced to 450. Rather, the payment of rupees 350 at different interval. It is a categorical statement of the defendant that since 2001, I have been paying 3 months together. 1 month when it fall due and the next 2 months in advance. Since 2001, this is the mode of payment which has been accepted by the plaintiff. Now, both the 15-day and falling due and this subsequent change all have been mixed up, and now come to say that this tendering of 3 months together is against the provisions of the act, because it has to be paid within a 15 day from the date it fallen due. Now here, what would appear that there was no due date, though it was initially in 1973, it was some date, but subsequently by the conduct of the parties, there was no due date. It is admitted by her also. At one point of time, she has revoked the termination. She has directed me to vacate. Then again, there's some conditions have come, that on this condition it will continue, and again this has been continued. The initial document exhibit 2 that lost its validity except to prove that he is a tenant. I cannot say I was never a tenant. To the extent of tenancy, but even in the WS also I have admitted I was a tenant. So far as the point of bona fide requirement is concerned, in the case of Anil Bajaj and another and Vinod Ahuja 2014-15 SSC 610, the Supreme Court of India held that it would hardly require any rectification of the subtle principle of law that it is not for the tenant to dictate to the landlord as to how a property belonging to the landlord should be utilized by him for purpose of his business. Also, the fact that the landlord is doing business from various other premises cannot foreclose his right to seek eviction from the tenant premises so long as he intends to use the same tenanted premises for his own business. This is not my case, my lord. My submission in the written statement is something different, my lord. I said, what purpose she is required my premises, it has not been showed that she has acted on that particular requirement. It has not been spelled out in the plain, rather sought to.
No, the facts may be different in different cases, but
Lordship.
whether the proposition of law laid down in the said case is applicable
Proposition,
to
yes,
your
I
case or
cannot
not.
dictate how the my lord, tenanted premises would be utilized by the landlord. That is the my lord, law, my lord.
Hmm.
But to that, my lord, that it, how the my lord, tenanted premises will be utilized by the landlord, he has to show his bona fide. Just because for evicting the tenant, he cannot come up with a plea that he need.
So, whether Supreme Court has laid down any parameter to that extent
I'll be
in that respect.
Well, I'll try to support it by some of the judgments, my lord. I'll try, my lord. Paragraph 24. In the case in hand, it is not disputed that the plaintiff is a company. It is also an undeniable fact that the company has business on its own, including tea plantation, etc. The company intends to expand its business by raising construction over its own land. My lord, where from it has got, my lord. It is not in his evidence, not in his plain, my lord. It is only because of this exhibit 2, my lord, which were objected regarding permission. This has come up, my lord. It has already obtained required permission from Dibrugarh Development Authority, exhibit 97, 98, 101, 102 due to these are all under objection, my lord. Due to non-delivery of the vacant position of the defendant tenant, the company is not in a position to raise its construction, as a result of which the company is suffering a lot. Accordingly, I am of the considered view, both the to hold that the learned trial court has rightly concluded the issue of bona fide requirement in favor of the landlord, and I do not find anything to interfere with the findings. Now, my lord, so far as issues are concerned, my lord, I am concerned only issue number 3, 4, and 5. These are not separately discussed here. Neither the issue number 5 has been discussed. At any point of time, my lord, the entire judgment has been, my lord, approved by the appellate court, my lord. Now, on the point of, my lord, so far as evidence, my lord, I'll not go into accept, my lord, saying that particular evidence of the defendant, paragraph 16, as I have already pointed out.
No, it appears that trial court has first appellate court has dealt with all the issues. This limitation issue was discussed.
My lord,
This
the
defaulter issue was discussed.
Defaulter is
This
discussed.
bona fide requirement issue was also discussed.
So far as defaulter point is concerned, as I have already indicated that the trial court has found me to be a defaulter from June 2008. The appellate court has come up with the June, March, April, May 2009. So
Okay, this is in connection with?
my lord, is order of 41 rule 31, my lord. I'm relying on paragraph 15, my lord. And 16.
Yes.
A perusal of the judgment of the trial court shows that it has exclusively dealt with oral and documentary evidence adduced by the parties for deciding the issues on which the parties went to trial. It is also founded in support of his plea of adverse position on the disputed let the defendant did not produce any documentary evidence while the oral evidences by the defendant was conflicting in nature and hence unworthy of reliance. The first appellate court has in a very cryptic manner reversed the finding on the question of position and disposition as alleged by the plaintiff, as also on the question of adverse position as pleaded by the defendant. The appellate court has jurisdiction to reverse or affirm the finding of the trial court. The first appellate court is a valuable right of the parties and unless restricted by law, the whole case is therein open for rehearing both on question of fact and law. The judgment of the appellate court must therefore reflect its conscious application of mind and record findings supported by reasons on all the issues arising along with the contention put forth and praised by the parties for decision of the appellate court. The task of an appellate court affirming the finding of the trial court is an easier one. Then of our High Court, my lord. Here I am relying on the paragraph 33 and 34. The provisions of Order 41, Rule 31 of the Code of Civil Procedure are mandatory, and if the judgment of the appellate court does not follow the provisions of Orders 41 and Rule 3, the judgment is vitiated. Now, this court is of the opinion that the first appellate court judgment is vitiated for failure to draw up a point of determination and for failure to answer all issues. Therefore, the first appellate court judgment is set aside. This of our High Court, I'm relying on page 54. On the right hand side, last paragraph starts with in order to prove. In order to prove that the plaintiff's need was bona fide, real and genuine for construction of hospital on the land in question, it was necessary for the plaintiff to have proved that firstly, they had obtained a sanction map for construction of such hospital from municipal authorities and from all other agencies involving in granting permission of construction of such a big hospital. Secondly, adequate funds needed for making such construction should have been proved that they are available. And lastly, whether plaintiff have arranged for sufficient staff to run such hospital after its completion and or what planning and arrangement are made by them to run such hospital once it is completed. No evidence was filed to prove any of these material facts. Now here in our case, it is not pleaded even. Now, in the appeal memo, we have given as many as 20 judgment method, 15 judgment method. None of them have been discussed. Now, one another aspect here is that though court has found that in the NJ cases, I have tendered, but it is, there's no date, etc. And insistence on the court is, my lord, from the judgment, it appears that the physical tendering is necessary. Now, when a situation arises that the landlord and the tenant's relationship become, my lord, strange. Now here your lordship will find, my lord, since 80 onwards, she has been issuing these or the other notices on different angles, on different reasons, my lord. Lastly, my lord, the bank draft was, my lord, prepared and it was sent by registered post. She has accepted for nearly 3 years. Then, my lord, from 2001, she has refused to receive the, my lord, registered post, which was tendered the last bank draft. And thereafter, we have, my lord, tendered it, and then we started depositing the amount in the court. Now, so far as this strange relationship is concerned, my lord, in one of the judgment of our court, my lord. Yes, actually. So put to the 77 to the. This AR 1977 Supreme Court 1198. Paragraph 3. Paragraph 3, 10th line from bottom, starts with, if the landlord refuses to accept rent. If the landlord refuses to accept rent paid to him, a deposit is permissible, but payment need not be by physical tender, person to person. It can be by money order or through messenger, or by sending a notice to the landlord asking him to nominate a bank into which the rent may be regularly paid to the credited to the landlord. If the landlord refuses under this circumstance, then a court deposit will be the remedy. Now here we have issued the bank draft by registered post till 2001. The last one, see, having been refused, then only we have started to deposit in the court. And this has been relied on by our court, in 1986 1 JLR 442.
That's all right, but whether you have made such averment in your written statement?
Yes, yes. Yes.
Then whether you have tendered evidence to that effect?
Yes, the paragraph 16, initially I have told the evidence, page 59 of the evidence. This extra bunch I have submitted. It is also in the record. In paragraph 16, I said that the defendant since September 2008 started offering tendering rent in cash, and on refusal thereto by the plaintiff to accept, started depositing the same regularly in court, and on such successive refusal have deposited the same up to May 2012.
Paragraph number?
16. Lordship can read from paragraph 15 also. my lord.
Paragraph number
15
16 at page number 33.
My lord, in the extra bunch I have to give it.
Extra bunch, and that is not available here.
It was filed on 26/9/18.
23. 23.
26/9/2018.
Page number?
Page number 61. Has your lordship got it?
Yes.
Paragraph 15. That the plaintiff has refused to accept payment of rent for the months since June 2018 to August 2008, when sent to it through registered AD post by banker check number so-and-so dated so-and-so for rupees 1050, which the plaintiff had to then deposit
No,
in.
no, whether you have mentioned in your written statement, this averment?
No,
But this is evidence. This written statement was filed on 9/8/2006. During the continuation of the proceeding, I have still continuing. All the default what has been pointed out by the court, the trial court, this is during the pendency of the suit, because my obligation to pay the rent still subsists. Every month I have to deposit. So during the continuation of the proceeding also, I have tendered and given. That's what the 2008, otherwise this WS has been filed in 2006. Because the landlord can prove my defaulter even by during the subsistence of the lease, by bringing on the case, the Miss NJ cases, if I have deposited.
Okay. Original title. What? Yeah, original title.
The appellate court even considered the NJ cases of 2009, that is subsequent to filing the evidence also. That is also permission.
WC not. C1. Yes, any other point?
Page 61, madam, that I have shown. What I was impressing upon your lordship, madam, the appellate court has also considered the NJ cases of 2009. That is after my laying the evidence. Paragraph 15, my lord, page 61.
Hmm.
Since my lord, these two paragraph clearly, my lord, squarely covers by the decision already referred, my lord, 1986 one, GLR 442 and AR 77, Supreme Court 1198. I have already given, my lord. Paragraph 15 and 16, that the plaintiff then refused to accept payment for rent for the months since June 2008 to August 2008, when sent to it through registered AD post, right, banker check number so and so dated for rupees 1050, which the plaintiff had to then deposit in court via Mizze case number 65508. That the defendant since September 2008 started offering tendering rent in cash, and on refusal thereof by the plaintiff to accept, started depositing the same regularly in court. On such successive refusal, have deposited the same up to May 2012.
Hmm.
But whether even after refusal, successive refusal, I am bound to tender every time. In that connection, this judgment of the apex court, AR 77, Supreme Court 1985. SP Deshmukh versus Shah Niyat Chand. '89 one SSC. 89 one SSC. I'm sorry, my lord, the judgments are not arranged. This I'll be submitting, my lord, after some time, my lord,
Hmm.
after submission of the council.
Mm.
Basically, what the judgment would be, my lord, first of all, my lord, though there is a date fixed for tendering the rent,
Hmm.
if it is varied by the mutually by the parties and rents have been received, in that case, the original date, whatever, it cannot be said that the tenant has defaulted. That judgment of I have already, my lord, submitted. The second one,
Hmm.
when can I deposit the rent in court? That I have to tender.
Hmm.
So far as, my lord, statement in the evidence, I have already, my lord, there, my lord, that I have tendered, it was refused, and thereafter successive refusal, I have deposited in the court.
Hmm.
Now, whether it is necessary to, my lord, tender, my lord, on that, my lord, that is the, my lord, decision of AR 1977, my lord, Supreme Court 1985. The decision is not there, but only the content is there. So, and also, my lord, of 1989 1 SSC 542.
Hmm.
Let my friend be continued with that, my lord, and in the meantime, I'll bring those judgments. My lord.
Hmm. So your part is completed.
Three or four judgment, my lord, I'll just submit.
Okay,
with
okay,
the
your part is
meantime.
completed.
Otherwise, my lord, I have completed. My lord, my
Okay.
first submission is that the judgment of the appellate court is not according to the order of 41 Rule 31.
Yes.
Secondly, my lord, there was no due date of payment, because subsequently the arrangement have been changed. Both the courts have also accepted that one. Only fault that both the courts have found, so far as the trial court is concerned, in respect of depositing of the rent in the court for the month of June 2008, and the appellate court for the month of March, April, May. And that I did not tender.
Hmm.
That is the my argument is, my lord. I'll just give the supporting the judgments.
Yes.
Yes. May it please your lordship. My lord, my learned senior colleague has already taken this honorable court with the pleadings, my lord. I will not reiterate all the pleadings, but my lord, at the very first instance, lordship, I will just submit before your lordship that your lordship is exercising revisional jurisdiction as enumerated under section 115 of the CPC. Lordship will kindly take up section 115 of CPC, my lord.
Yes.
Yes, may I read it, my lord? 115 revision. The High Court may call for the record of any case which has been decided by any court subordinate to such High Court and in which no appeal lies thereto. And if such subordinate court appears to have exercised the jurisdiction not vested in by law, or who have failed to exercise their jurisdiction so vested, or to have acted in exercise of its jurisdiction illegally or with material irregularity, the High Court may make such order in the case it thinks fit. So, my lord, interference in respect of the impugned orders will only entail when, my lord, either of these three conditions are, my lord, satisfied by this honorable court. Now, what is that jurisdictional error that has been committed by the learned courts below? That has not been pointed out to your lordships, my lord. So on this count alone, in my humble submission, this honorable court will negate this civil revision petition, my lord. I need not reiterate, my lord. Lordship will not reappreciate the evidence in revisional jurisdiction. It's settled position of law. Only when the conditions enumerated on those three conditions under section 115, then only lordship interference is called for. Which, in my humble submission, they have miserably failed to, my lord, establish.
Any other point?
Yes, my lord. Lordship, my learned senior has already taken to your lordship through all the pleadings in a very elaborate manner. But one or two, 3 points that has been skipped, my lord, those points I would like to point out to your lordship. Lordship will kindly take up their written statement in defense. That is annexed at page 31 of the civil revision petition, my lord. Page 31 of the CRT.
Yes.
It starts at page 31. Lordship, para 3, I am bringing to your lordship notice that the suit is barred by limitation in advances having been filed on so and so after a lapse of more than 26 years beyond the statutory period of 12 years of termination of lease with effect from so and so. Document and their lawyer's notice dated 11 to 1980 through Mrs. Steele and Haddo, solicitors and advocates. Now, lordship will kindly mark those last few lines. The defendant has since been occupying the suit premises as trespasser and not as a tenant. He himself, in his written statement of defense, admits to be a trespasser, my lord, which is much worse. And he reiterates, my lord, at para 18.5 at page 34, he again reiterates that he is a trespasser. At para 18.5 of the same written statement of defense, he again reiterates.
18.5
at page 34. The worst case, my lord. The defendant has since been occupying the suit premises allegedly as trespasser and not as a tenant. Now, my lord, coming to the And again, in his, my lord, that evidence and affidavit, again, the same thing has been reiterated, my lord. That additional bonds are furnished to this honorable court by the learned senior. The evidence of affidavit of the defendant is at my lord, page 59, it starts. At page 60, lordship will sign. Page 60, para 8, my lord. That I have since been occupying the suit premises allegedly as trespasser and not as intended.
No, that is allegedly.
Yes, my lord, but that is his admission, my lord. He himself admits, my lord. Anyway, my lord, just I wanted to point out that he himself admits to be a trespasser, my lord. So no question of him possessing. Anyway, now let us come
Would
to
it
the
amount
merit of,
to admission?
my lord.
Would it amount
In
to
my
admission?
humble submission, it amounts to admission, my lord. Because on oath he is stating that, my lord. Anyway, lordship, let us now come to the merits of the case, my lord. Now, my learned senior has argued that the honorable trial court below, my lord, while deciding that he is a defaulter, my lord, committed some mistakes or error in as much as he has tendered the rent initially by a check, and subsequently, my lord, he says that he has tendered by cash, which the plaintiff refused, and thereafter he has started depositing before the honorable court as per law. Now, my lord, in this regard, what is the provision under which a rent is to be deposited? It is covered by, my lord, section 5 of the Urban Areas Rent Control Act, which will kindly take up that. That's it, section 5 of the Urban Areas Rent Control Act. 5E, 5(1)E.
Yes.
No decree, no order or decree for the recovery or possession of any house shall be made or executed by any court so long as the tenant pays rent to the full extent allowable under this act and performs the conditions of the tenancy. My lord will kindly come to small e, where the tenant has not paid the rent lawfully due from him in respect of the house with a fortnight of its falling due. And also lordship 5(4), next page, section 5, subsection 4. Where the landlord refuses to accept the lawful rent offered by his tenant, the tenant may, within a fortnight of its becoming due, deposit in the court the amount of such rent together with the process fee for service of notice upon the landlord, and on receiving such deposit, the court shall cause a notice to the receipt of such deposit to be served on the landlord, and the amount of the deposit may thereafter be withdrawn by the landlord on application made by him to the court in that behalf. A tenant who has made such deposit shall not be treated as a defaulter under clause E of the proviso to subsection 1 of this section. Now, my lord, these two provisions, in my humble submission, my lord, categorically provides that of tender, that means an offer has to be there, my lord. First, the offer has to be there, and if the offer of rent is refused by the landlord, then only the question of depositing before the court will come. And in this
No,
regard,
it is his averment that it was refused.
no, my lord, that is why he has to show how he has tendered. The refusal will only come if he can show that he has tendered. The trial court below has rightly gone through the misdeed cases, and nowhere it has been, my lord, brought on evidence or on record to show how it was tendered, my lord. There at paragraph 16 of that additional bonds of his evidence of affidavit, he simply says that he has, my lord, offered and it has been refused. It's a vague statement, my lord. It is not supported by any evidence, my lord. In fact, to the contrary, the learned court below has perused the evidence in my lord, the Misde cases by which the rent was tendered before the court, and there nothing was mentioned there, my lord. And such refusal is not under written statement of defense. It has been taken in the evidence of affidavit only, that too without any, my lord, supporting material. That is happening. And on the point of this, I would like to refer to two judgments. One is of our Honorable High Court only. Lordship will, same, my lord, Urban Areas Rent Control Act, Section 5 was under consideration. Lordship will kindly peruse, go through. I will rely on para 13, 14, and 15. 13, 14, my lord, the case laws have been discussed. Lordship will kindly directly come
No,
to.
these are the cases discussed here in this.
Yes, yes, it has been discussed.
But where is the ratio of this case?
Yes, at para 15, my lord. 1-5. Last page of that judgment, my lord. Yeah. May I read it, my lord?
Yes.
On meticulous scanning of the impugned judgments and decree of the courts below, and also having regard to the above cited cases, as well as upon hearing learned counsel for the rival parties, this court is of the view that the learned courts below were correct and right in holding that the petitioners were defaulters in respect of non-payment of rent in question in due time as prescribed under the law. A lump sum payment of amount in advance is not permissible under the Act. That apart, Section 5(4) clearly indicates that for every deposit in the court, a proper notice along with the process fee must be rendered, failing which such deposit cannot be said to be a legal deposit. It is settled that issuance of notice in depositing the rent in the court is mandatory, and any deviation of the same would take away the protection given to a tenant under the Act. An ordinary reading of the provision of law as contained in Section 5(4) of the Act manifestly indicates that payment of rent in the court by the tenant is permissible only where would be a refusal from the landlord to accept such rent, and such deposit in the court is required to be made within a fortnight of its becoming due, and that too with proper notice accompanying the process fees, so as to intimate the landlord of such deposit of the rent in the court, failing which the tenant shall be treated as a defaulter. So, my lord, in our case, my lord, first, there was, in my humble submission, my lord, apparent from the impugned judgment, there was no tender or offer, my lord, and lump sum deposit of rent for months together is also not permissible as per this provision, Section 5 of Urban Areas Rent Control Act. So, my lord, the trial courts below rightly decided, my lord, in fact, the Section 5 of this Urban Areas Rent Control Act was taken to the Honorable Supreme Court for adjudication, my lord. That one judgment of the Supreme Court on this point, my lord, also will kindly permit me to place. It's 2018-12 SCC, page 551, Manjushri Chakrabarti versus M. Ahmed Bhuiyan. I will be relying on para 9 and 10, my lord. Para 9. The question to be determined is whether the respondent tenant actually tendered areas of rent from the date due. Having accepted the date of receipt of the demand notice as the date when the rent became due and payable, the same had to be tendered within a fortnight thereof. It is the case of the respondent tenant that the same was factually and actually tendered within a fortnight, contemplated under Section 5(1)(e). But the personal tender made by the respondent tenant was not accepted by the landlord. It is in the aforesaid circumstances that the areas of rent came to be deposited before the trial court on 1/9/2000, para 10. The situation where rent tendered by a tenant is not accepted by the landlord is governed by Section 5(4) of the 1972 Act. By virtue of the liberty available to a tenant under Section 5(4) of the 1972 Act, the period of deposit of area rent with the court concerned is also a fortnight from the date when the rent had become due. Since we have already concluded herein above that the rent had become due and payable on 17/8/2000, we are of the view that the period of a fortnight to make the deposit of areas of rent in a court would expire on 31/8/2000. The deposit made by the respondent tenant on 1/9/2000 was therefore clearly beyond the period contemplated under Section 5(4) of Act of 1972. It is therefore apparent that the claim raised by the appellant landlord for non-payment of areas of rent was liable to be accepted as the areas were not deposited within the postulated time. So, my lord, Honorable Supreme Court has upheld, my lord. The view taken by the trial courts below has already been upheld, my lord. In the instant case, he admittedly says he has been depositing rent for months together. That is not permissible. He has to make the rent monthly. Next, my lord, before depositing the rent, there has to be an offer. That is also not there. And regarding my lord, the date of due, on which date the rent becomes due, my learned senior colleague has raised an objection. But his evidence on affidavit, he has clearly stated it is on 15, my lord. Lordship will again come to the Lordship will tabulate you. Tabulate Lordship once again, my lord, his evidence on affidavit. The additional bunch, my lord. His evidence on affidavit starts at page 59. 59. Para 3, my lord.
Yes.
Yes, that I came to occupy both the suit premises described in schedules A and B of the plain, agreeing to pay rent by 15th of the succeeding month. So it is clear his case, he has agreed to pay the rent by 15th of each month, my lord. So what wrong did the courts below committed in taking this date to be the due date, my lord? So in my humble submission, my lord, both the courts below, my lord, framed the issues and decided the issues after a detailed discussion and considering the materials available on record and adduced by both the parties, my lord. Now, my lord, under similar circumstances of the same party, my lord, there was another eviction suit. And that was also decreed in favor of the plaintiff, same plaintiff here, my lord. And this honorable court has the occasion to deal with it. And identical objections were raised here also, my lord. My lord, the citation is 2017 4 GLP, page 57. Same, my lord, defaulter section 5(1)(e) and 5(4) and bona fide requirement. Lordship, I will not trouble you with the facts because everything is identical. Lordship, kindly, I will refer to para 39, 40, and 41. The findings, my lord. Different tenant, the plaintiff is same here, my lord. Para 39. Hence, the third point of determination is decided in affirmative against the petitioner by holding that the tenant is a defaulter, having deposited rent irregularly in the court without first offering it to the respondent, and such deposit of rents in court were contrary to the requirement of Section 5(4) of the Assam Urban Areas Rent Control Act 1972. 40. As regards the fourth point of determination carried out by this court, in view of the discussions made therein before this court, finds that while the concurrent finding of fact were twofold, The first being that the petitioner herein was a defaulter, which had a valid ground for evicting a tenant. And the second concurrent finding of fact by both the courts below was that the suit premises were bona fide required by the respondent for construction of RCC building thereon, for which the respondent had procured a permission for construction from the authorities, which was extended by the respondent during the pendency of the suit. Even at this revisional stage, when the scope for reappreciating evidence on record is limited, yet from the materials available on record, it could not be demonstrated that the requirements of the suit premises by the respondent was not a bona fide one, in one words, not genuine. In other words, not genuine. It may be pertinent to refer to the case of Anil Bajaj and another versus Vinod Ahuja reported in so, wherein the Honorable Apex Court has held that it would hardly require any reiteration of the settled principle of law that it is not for the tenant to dictate to the landlord as to how the property belonging to the landlord should be utilized by him for the purpose of the business. Also, the fact that the landlord is doing business from various other premises cannot foreclose his right to seek eviction from the tenanted premises so long as he intends to use the same tenanted premises for his own business. Para 41. On a careful scrutiny of the judgments of both the courts below, there is no material available to show that the decision was vitiated by any misreading of the pleadings or misreading or misconstruction of any evidence on record. It also does not disclose that the courts below had exercised the jurisdiction not vested by law. It could not be demonstrated that the courts below had failed to exercise the jurisdiction so vested by law. Moreover, from the discussion made above, it cannot be accepted that the courts below have exercised its jurisdiction illegally or with material irregularity. Rather, this court is of the view that the statements made in the written statement prima facie does not disclose that the monthly rent was offered to the respondent on month-to-month basis, and on refusal to accept such rent, the rent for each month was deposited in court within the fortnight of its falling due. Hence, this court does not find even a prima facie case requiring a fresh application of the evidence recorded by the learned trial court. It is no longer res integra that in exercise of revisional powers, a revisional court is not to act like a court of appeal, and it could interfere only if the exercise on the grounds prescribed in section 115 of the CPC can be successfully demonstrated, which is found to be absent in the present case in hand. Therefore, the concurrent finding on the issue that bona fide requirement of the suit premises and the petitioner is defaulter, as held by the learned courts below, are not liable to be dislodged. On identical fact situation. So, my lord, and another aspect, my lord, my learned senior has said, wherefrom the appellate court came to know that the plaintiff is a company and is doing business. Lordship will kindly come to my plaint. It has been annexed at Annex her. The plaint starts at, my lord, page 19 of the CRP. Lordship will kindly turn to page 20.
No, it is there in the plain.
Yes, that the first paragraph, the
So
plaintiff
no
is a
need to argue on this point.
my lord. So it is apparent, my lord, that the learned courts below committed no wrong in my lord, declaring the suit in my favor, because apparently the tenant is a defaulter, he having failed to deposit the rents as per the prescription of section 5 of the Assam Urban Areas Rent Control Act. And the learned court has also rightly decided the issue that the suit premises is bona fide required by the plaintiff, my lord. And in the, my lord, CRP, we have filed an additional affidavit to show that he is also possessing, my lord, flat and a landed property, my lord. If your lordships want, I can place that one.
Not necessary.
So, my lord, in my humble submission, this civil revision petition is my lord, devoid of any merit and warrants my lord dismissal at the hands of this honorable court. That is my humble submission.
Yes.
Only one point in clarification, Madam. In the judgment of the appellate court at page 81, my contention was that the finding of the court is that the company intends to expand its business by raising construction over its own land. This is not in the plain. This statement is not, I am not saying that it is not a company, but this contention that intends to expand its business by raising construction over its own land. It is not there in the plain.
Page number?
Page number 81, second last line. Page number 81.
Eighty-one of the bonds you have submitted?
No, my lord, CRP, my lord, civil division.
What's CRP?
Civil division section. Part of the judgment of the appellate.
Yes.
Last two lines.
Paragraph number?
24, last two lines. The company intends to expand its business by raising construction over its own land. This is only because of this exhibit 98, 97, 98, 101 and 100. If they are not pleaded case, nor in the list of dates, nor leave of the court has been taken, and it was under objection. Now, with regard to the two judgment, what I could not submit the earlier. Firstly, is the that AR 1977. It's only one page judgment.
Yes.
12th line from the top. This sentence
Paragraph
starts.
number? Paragraph number?
It's only two paragraph. Paragraph 1.
What's
AR 1977,
Okay.
Supreme Court 1985.
Okay.
Paragraph 1. Line number 12, my lord. SP this one.
Yes.
They start with normally. Normally 12th line. Normally monthly tenant is under an obligation to pay the rent from month to month, but this obligation is subject to a contract to the contrary. Such a contract need not be reflected in a formal document and can be spelled out from the conduct of the parties spread over fairly a long period of time. The evidence in this case, which was believed by the two tribunals of facts, shows that the tenant has paying rent at an interval of 3 or 4 months, which the landlord has been willingly accepting and always without even so much as a murmur. Now here is the same case, my lord. Then, my lord, relying on this, my lord, the subsequent judgment of the Supreme Court, my lord, 1989 1 SCC 542, Rasiklal versus Gokul Das.
Which paragraph?
My lord, paragraph 8. It was relied on the smoke case, my lord, from 3rd onwards. In the SP's Deshmukh case, the rent has been paid at a variant interval of 3 or 4 months. The crucial test appears to be the conduct of the landlord in receiving the rent offered belatedly. if he receives the same under protest and wants the tenant to be regular in payment in future, he cannot be assumed to have agreed to modify the agreed in this regard. But if the without any objection and without letting the tenant know his thought process continues to receive rent at interval of several months, he cannot be allowed to spring a surprise on the tenant by suddenly starting a proceeding for eviction. Having lulled the tenant in the behalf that things were all right, the landlord was under a duty to serve him with a notice demanding regular payment if he wishes to insist upon it. In the case before us, there was no objection whatever raised on behalf of the landlord against the delayed payments. Now the objections, whatever has been raised is on the quantum, not on delay. The moment it was paid, he has accepted. That he has seen since my lord inception. So, and 2000 onwards, continuously he has been receiving for 3 months together until 2006. Then bankrupt. And the last my lord on bona fide requirement, 2003 1 GLR 296.
No, the law is settled by the Supreme Court. Where is the point for looking to the decision of High Court?
Hello?
No, law on this point is settled by the Supreme Court.
Lordship.
Then where is the point for looking to the decision of High Court?
No, but this is regarding bona fide requirement.
Yes, bona fide requirement has already been dealt with by the Supreme Court in number of cases.
My lord, the ratio, ratio is there that the tenant cannot dictate the terms. But at the same time, my lord, honest and the bona fide requirement, it has to be established by him. My lord. And therefore, the judgment, my lord, relying on the various Supreme Court judgment only, this court also, my lord, has said what is the my lord, honest and my lord, bona fide requirement. 2003 1 GLR 296, paragraph 7. All cases, my lord, trial court has relied on of the Supreme Court. These have been referred also. My lord. Raghavendra Kumar, the farm CC, my lord, that is, this has also been relied here.
Okay, we'll see.
Lordship.
Pardon, sir, please assert here, learned senior counsel assisted by Mr. R.S. Mishra, learned counsel for the petitioner, and Mr.
J. Patwari.
J. Patwari, learned counsel for the respondent. Argument concluded, judgment reserved.
I am obliged to your lordship for a patient, my lord.
Should be yes.
Timing item number 24 for admission.
Sorry, my lord, I was in some other court.
But the other side seems to be.
That is why.
But Mr. Soduri, where is your interim pair here?
My lord.
What is your interim pair in this?
So, my lord, in these circumstances, since they're taking time, lot of time, my lord, all that I'm saying is status quo regarding our service should be maintained. Let them file their affidavit. Lordship will take a call on the next day.
No, that is not in your prayer.
So in the writ petition, there is interim is there, my lord. Pending disposal of the rule, it may be observed that pendants shall not be a bar to grant appropriate relief to the petitioner in accordance with law, such other appropriate other orders. Actually, my lord, the whole issue is the government themselves has taken a decision. In either of the three way, our cases would be considered. Now it is pending consideration. Now, Lordship has noticed how government has taken up the matter with the director. Director has called for the information from the respective principal. Now, with all the information, matter is submitted before the authority. The authority is taking time. That's why we are, because in our place, some again some ad hoc appointments could be made, replaced by another set of ad hoc. That is also not permissible. Or lordships can say that we will not be replaced by another contract employees, my lord, until the matter is decided. tomorrow the respective principals can issue an advertisement also for filling up the post on contractual basis.
No, that is only your presumption.
Not presumption, my lord, that is a probability.
No.
All that we are saying is, my lord, since it is a matter which emanated from the government itself, it's not that, my lord, at our
No,
instance.
had there been one advertisement, then the position would have been different.
Correct.
Here, there is no such effort on the part of the respondents.
Or in that case, my lord, lordship will ask them to file the affidavit and fix the matter for disposal at an early date, my lord.
That can be done.
Yes.
That can be done. But today,
No, not today, my lord, not today.
no. The party is absent today. In the morning, though, they remain present.
Yes, they were there. It was my fault in the morning. I could not be present. I cannot blame
Kobe,
them.
is
But
the
we
number
will give a
available
date after 2 weeks, we'll inform them, my lord.
after?
2 weeks. We'll inform them. They should file their affidavit.
Okay. He's trying to contact her.
Okay.
So, or can we fix it on a Friday then?
Yes, it can be done, my lord.
Okay.
Or lordship can pass the order, my lord. We'll inform them, my lord, that they were praying for, 2 weeks time, I think. Lordship will done in 2 weeks time.
No,
I think they was
yesterday,
praying for 3 weeks time.
yesterday that was the pair.
Ah.
But today I don't know.
Anyway, my lord, we may wait for some time. Maybe they will turn up. Or lordship can fix it on Friday.
Friday. Okay.
Okay.
As agreed by learned advocates of both sides, rest and list the matter on Friday.
Timing item 12 for hearing.
Itu পাঠাটা আছে।
Pardon me.
May please, yes, my lord. My lord, on the last occasion when the matter was taken up, my lord, I had referred to page number 35, where my lord declaration
This is not a part-heard case, perhaps.
This is a part-heard. This is a part-heard. My lord, may remember that, my lord, the declaration was given only in respect of 1/4 of the Schedule B land, whereas, my lord, recovery of possession was given in respect of the complete Schedule B plot of land. So that was the perversity that I had pointed out, and my lord had opined, then my learned senior colleague friend, my lord, she concluded that, my lord, under section 152 of the CPC, my lord, that can be corrected at the execution stage. So my lord wanted to know whether there is any judgment that perversity and error that has cropped up because of perversity that can be corrected under 152 of the CPC.
Lordship will hear this matter today itself, Lordship.
Would the time permit us?
Lordship. It will take some time, Lordship.
So let us fix it on a when. So before vacation, hearing matter cannot be taken up. We have already fixed a lot of matters. After vacation, suggested that.
It's because, Lordship, not only on that point, Lordship, the Schedule B clearly mentioned the amount of land which we want in our possession, Lordship. That is already mentioned in Schedule B. So even if there is a direction for recovery of Schedule B, it means that portion only. So it is not a case that entire Schedule B land will be given in possession to the decree holders, Lordship.
But that is not clear from the order purpose.
In Schedule B, it is clearly mentioned that out of which
Okay,
one
all right,
portion,
then let us fix it that.
Lordship. Lordship has already heard this matter. Can it be before vacation, Lordship? We can.
Before vacation may not be possible. A
On
lot of
10th.
matters have already been fixed, part-heard matters. So may not
Lordship,
reach.
can it be on a Thursday, 19th September at 2 PM, Lordship?
No,
that
no,
we
no,
can
no,
complete?
madam, no. Before vacation, no. After vacation.
24th October.
24th of
It's a Thursday, Lordship.
applies.
As agreed by
Okay.
learned advocates about the parties, let's the matter on 24th.
Item 20,
Please, your lordship. For this regular first appeal, my lord, is against the judgment, my lord, dated 7/7/2017, my lord. The issue involves very small, my lord, with regard to the interest part, my lord. The High Court has granted interest at the rate of rupees, my lord, 18%, my lord, 16%, my lord. That which we are agreed, my lord.
At the rate of rupees
16%, my lord.
16%.
On that part, my lord. The reason of granting such interest, my lord, has not been discussed, my lord. Section 34, my lord, the CPC deals with the granting of interest, my lord.
How the appellate court has dealt with the issue?
Lord, this is the first appeal, my lord. This is the first appeal.
This is first appeal.
My lord.
Acha, okay. Where is the substantial question of law? Oh, no, sorry.
The lordship will find the issue at page 31, my lord, regarding interest.
Yes.
My lord, court has found that plaintiff is entitled for amount, my lord, but the reason has not been assigned for granting, my lord, interest at 16%, my lord. Lordship, section 34, lordship, I would like to rely upon section 34 of CPC, my lord. Section 34 of CPC, my lord.
Yes.
Interest, where and in so far as a decree is for the payment of money, the court may, in the decree, order interest at such rate as the court deems reasonable to be paid on the principal sum adjudged from the date of the suit to the date of the decree, in addition to any interest adjudged on such principal sum for any period prior to institution of the suit, with further interest at such rate not exceeding 6% per annum as the court deems reasonable on such principal amount from the date of the decree to the date of payment, or to such earlier date as the court thinks fit, provided date where the liabilities in relation to the sum so adjudged had arisen out of a commercial transaction. The rate of such further interest may exceed 6% per annum, but shall not exceed the contractual rate of interest, or where there is no contractual rate, the rate at which monies are lent or advanced by nationalized bank in relation to commercial transactions. Now, my lord, the reason of assigning 16%, my lord, has not been dealt with, my lord. And my lord, nationalized bank also does not offer, my lord, or lend loan at 16%, my lord. I have got a chart of SBI, my lord, where the SBI, since 2010, my lord, the interest rate in 2010, the interest rate was 7.5%. Until 2024, it is 10.25%, my lord.
At the rate of rupees?
Initially, in 2010, the rate was 7.5%, my lord.
2000?
In 2010, my lord. And gradually it has been increased up to 10.25. I'm relying upon the, my lord, chart of SBI.
No, this judgment was passed in the year 2017.
My lord. I'm also relying on judgment, my lord. I've given the copy, my lord. 2009 Supreme Court 386, my lord. Here, my lord, the interest was granted at a rate of 24%,
Subsequently, court decreased it to 9%, my lord. Para 8 and 9, my lord. Paragraph 8 and 9, my lord.
Then you were agreeable to pay the interest at the rate of 9%. Agreeable. Yes, madam?
Wait, wait, ma'am. My lord, there is no dispute regarding the principal amount. The dispute is only regarding the interest.
Yes.
And that is why they have filed the appeal, my lord. If my lord, record to assemble. My lord takes up the list of documents which are relied upon by the plaintiff, my lord. The agreement which was signed by both the parties, my lord. There it is clearly stated that in case there is any default in payment on my part, then interest will be charged for default in payment at the rate of 24% per annum, my lord. That is the agreement which was drafted by them, the builders. My lord has a list of documents relied upon by the plaintiff, my lord, from the NCR, my lord. It is at page 22. Or my lord may take.
Yes.
In fact, my lord, section 34, which my learned friend just read, the proviso, my lord, provided that where the liability in relation to the sums were adjudged had arisen out of a commercial transaction, the rate of such further interest may exceed 6% per annum, but shall not exceed the contractual rate of interest. Or where there is no contractual rate, the
So the
rate at which.
contractual rate was 24%.
Yes, my lord. It was 24%. My lord, the trial court has rightfully granted 18%, my lord. In fact, I am also relying upon a judgment which has been passed by the Supreme Court of India, my lord, wherein one judgment which was passed by the NCDRC, my lord, that was put under challenge. If my lord takes up paragraph 11, my lord, page number 6 at the bottom. My lord, the dispute here is also more or less the same, which is the dispute in the present case, my lord, before my lord. Having considered the submissions of the learned counsel for the parties, we are in agreement with the findings recorded by the NCDRC regarding the conduct of both the parties. However, we feel that in the fitness of things and the interest of both the parties, considering the nature of agreement made, and also their conduct, that the order of the NCDRC requires to be modified. The rate of interest awarded is only 9%. Once we find that under the agreement in the event of default, the appellant's liability to pay interest on the defaulted amount could go up to 18%. It would be just and proper in the facts of the present case that 18% interest be awarded on the refund amount, my lord. So, my lord, in this case also, in case of default, the appellant was, the interest which was to be on the defaulted amount, my lord, was 18%. Accordingly, the Supreme Court decided that 9% interest is too less an amount. So, increase the interest awarded by NCDRC to 18%, my lord.
Lord, sir, may I kindly see the plaint, my lord, the prayer, my lord.
No, the principle laid down in the MSC cases is that 9% interest has to be awarded. And the principle is laid down by Supreme Court in the case of Upahar tragedy case.
My lord.
Is that judgment available with you?
My lord, the Upahar judgment.
Upahar tragedy is judgment. And that has been followed in subsequent MSC cases. Motor accident claim cases.
I thought
9% interest.
this particular transaction, my lord, is a contractual transaction, my lord.
Maybe.
It's a commercial transaction, my lord, as per section 34, my lord. The proviso clearly states that provided where the liability in relation to the sum so adjudged had arisen out of a commercial transaction, my lord. The rate of such further interest may exceed 6% per annum,
You
but
do
shall
one
not
thing,
exceed the
you-
contractual rate, my lord.
You produce,
Contractual rate, my lord, is 24% as per the agreement. In
But they
case
have
of
forgotten it.
default,
you produce the judgment of Upper Tragedy case. We will consider it on next day. 13 part. Mr. Learned Counsel for the appellant and Ms. Upadhyay, Learned Counsel for the respondent. Before Harry did it.
26 September.
obligement.
Item number 21.
May I please, Your Lordship? My lord, decision appeal, my lord, against the concurrent findings, my lord. And
Mr. Decker, today time may not permit.
I'm
us.
thinking also, I'm of my learned senior friend also here, my lord. Lordship may fix convenient date at least before vacation if possible, my lord. This is
Before vacation, not possible.
then, my lord, then. my
The
lord,
same thing will happen.
I understand, my lord. Then can it be on, my lord, on 22nd of October or 24?
24th, okay.
24, my lord.
As agreed by learned advocates of both the parties, recessal is the matter on 24th of October.
Item 22.
Lordship, may kindly fix any other date, Lordship. My senior is having some difficulty, he went away. And
When?
Lordship, as soon as possible, because Lordship, that they are enjoying the stay order, Lordship. 2 lakhs of rupees to the wife that has already been stayed by this honorable court. She has no money to survive, Lordship. I have filed a stay vacate petition, but on last date, Lordship inclined to take up the matter today for final disposal. If they have any problem, an early date if possible, Lordship.
Madam, you have already seen that we have, you
Yes,
have been
Lordship, I have
adjourning
seen-
the case.
I have seen, Lordship.
Mhm.
But this lady, Lordship, only 2 lakhs of rupees provided to her. That has already been stayed, Lordship.
Mm.
She is leaving parents' house, Lordship can imagine the difficulty she is facing. That's why only I'm praying.
When, go ahead. So 3rd of October before vacation?
Lordship. Deeply obliged.
As agreed.
Item number 25.
Lordship, in this matter, Your Lordship, the commissioner gives copies to both the sides with the signature. I have got it set if not. There are content signatures of client, both the advocates and the commissioner. And in which I have typed out, Your Lordship. Two sets of one, I think. There are 2 sets of sets.
There is a report from the registry. Flexi. Flexi is the report from the registry.
Yes, I have seen it.
Your Lordship, in this matter, in this cross-examination, Your Lordship, none of us were there excepting Mr. Talukdar. He was there, he's a counsel at that point of time, Your Lordship. He's still there. He cross-examined their witnesses also, and he was present in the cross-examination. His signature is also there, and the advocate for the plaintiff signature is also there, and the advocate commissioner signature is also there, Your Lordship. His document.
So copies of this deposition were furnished to both the parties.
Yes, both the parties by the commissioner.
Yes, Mr. Goswami, it is available with him.
I've given a copy.
Lordship, on last occasion, when I have shown the cross-examination part to your Lordship, Lordship has said that it is not available record. That is why this point arises. Originally, we also do not aware that record is not available in the, we should be, Lordship, truthful to the court. We have the copy of the deposition as a cross-examination with us, Lordship. That is why we have shown to the court, and court has verified that there is no record. Then we said that we should verify. After verification, we have not found the cross-examination part, but there is a cross-examination that is admitted fact. And secondly, Lordship, we have also verified today regarding the order sheet of the Honorable Court. The order sheet also not reflect that there is a cross-examination.
I flagged it. I flagged it on that day. I flagged that set is there. Just flagged. Signatures are there. Whatever.
I have noted down all the order sheet. I have noted all the order sheet. Lordship will find.
If your Lordship, my land is ready, let notice may go to these people, I'll verify it. If they are disputing this document.
Want to admit kuri kole kolu, ko dispute ri kolu hai. Ki je kotha koy. Controversy ki bolte hai. Isme bhi to commission.
Now, Mr. Goswami, what is your submission?
It is because, Lordship, there is a procedure in the Guwahati High Court Civil Rules and Order. When record is not available, the procedure has been laid down in the Guwahati High Court Civil Rules and Orders. How to reconstruct the record. That is a procedure. That is why last occasion also I am submitted. Because I have admitted that I have the copy of the cross-examination. But order sheet did not reflect. That is why I am saying, Lordship, the procedure should be followed. Nothing more than that, Lordship. Reconstruction by record is a procedure in Civil Rules and Orders. And otherwise, how Lordship will enter these documents?
No, reconstruction has to be done by the trial court, not by this court.
High Court also there is a rules.
Is it there in the rule?
Rules.
So the rule.
Civil Orders.
High Court. Civil Court rules. High Court rule of the Civil Court rules.
Before that, if Lordship want to see the record, original is here, 17 to 2016. (17 to 2016), there is a lower court order. DW3 file evidence on affidavit fixing 73316 for report from the Advocate Commissioner, Vandana Bhuya. Thereafter, Lordship, report has been sent to the Advocate Commissioner for report. Record. Thereafter, Lordship, on 11/5/16 failed to submit report. Next also failed to fix report. Thereafter, they have filed a petition that he may be allowed. They were defendant and the DW3 also defendant. So they want to cross-examine the DW3 from their side. They have prayed for the court.
That is Soben Mitra. DW don't pay. That's the confusion because we have a DW3 here also. Please tell the name also. Otherwise,
I'm saying from the court, from the record. Thereafter, Lordship, the Honorable Trial Court has allowed them to cross-examine the DW3, which has been examined. He has been evidence and petition filed. Thereafter, said that a witness was cross-examined. Petition was allowed by order dated 2/11/16. DW1 was cross-examined on 3/1/17. 3/1/17 it was cross-examined.
by them, by you, there are others.
DW want to cross-examine upon the petition. He's
not DW1. There are two DW.
Number to Soben Miki was allowed to cross-examine by order dated 3/1/17, and he was cross-examined. Thereafter, Lordship, case was fixed for argument. Lordship, kindly see 3/1/17. Order dated 3/1/17.
The last
Shobhan Miki,
Lordship.
he is not the DW. DWs are DW1 Nolin Miki.
Yes, yes,
DW2 Ravat
yes,
Teron.
yes. Yes, your lordship.
And DW3 is Gozen Bay.
Yes, yes, these are three, these are three.
Before that, there is another Shobhan Miki.
That's a wrong thing they have committed. Your lordship, what has happened? He was defendant number 3. He was defendant, no, that don't mix up DW and defendant. He was defendant number 3. He was supporting the plaintiff. So that's why you cross-examine him. That's why he was cross at the end. After our examination, your lordship. If your lordship see the dates, it is all 2016 and this thing we had examined. He's in 2017. See, they brought we sought for cross-examination Shobhan Miki because he appeared, he support the case of plaintiff. That's why cross-examining. That cross-examination is on the record here. So that is the DW1, DW2, DW3 is our witness, which they have cross-examined. And Shobhan Miki has been made DW, which it should have been PW. Because he was support. They didn't bring him, but he came to support in the plaintiff.
He was a defendant, that is why he was DW.
No, how can he be defendant? How can he be defendant DW? He's supporting you, and yeah, the decree is in favor of defendant number 1 also. Your lordship, one defend because your lordship, my learned friend sidetrack the whole issue from the main issue. Yes, conveniently he's not going to his issues on evidence. He's trying to find fault in my deposition. That's not the issue, your lordship. He has to build up his case on his own case, not on my. If there is shortcoming, he cannot build up his case on my shortcomings. Because judgments are saying that they have to establish the title and everything on their own, on the basis of their evidence. He's shunting us. He's trying to plug in the cross-examination of the DWs. Even DWs, suppose if your lordship DWs are not considered also, I'm taking for example, even I have not laid any evidence, examination. They have to establish with their prosecutor, plaintiff witness, which they are not able to do it. The whole case is gone. Actually, the issue is something else. He has gone to something else. Because this issue is not an issue at all, your lordship. If the documents are there, it may have misplaced somewhere. The file, if your lordship see that file is all or the tag is taken out. There is no tag here. It's all loose papers. If your lordship see, 5 compiles are all tagged up with stuff. The 6th document is all loose paper. They might have gone out somewhere. I'm not placing fault to anyone. But the question is missing from the record. And that missing from the record cannot be taken advantage by anyone, your lordship.
No, cannot be because this photostat copies are available with
Yes,
both the
sir,
parties. Both the parties.
That he can carry on the matter, your lordship. Instead of going to all this technicalities, your lordship.
Yes, Mr. Goswami.
I have no objection if they like to submit like this. I have no objection. I can argue the case. I argue the case. Case basically is this, lordship. Case is lordship. Want to hear the matter, lordship? Case is basically like this, lordship. One sale deed was executed by 2 persons in favor of the plaintiff. Sale deed has been executed. Thereafter, patta has been issued, and thereafter, lordship, the holding has been issued in favor of the petition. They have filed a case before the Board of Revenue. Board of Revenue interpreted the sale deed, stating that sale deed should be executed in the name of Rais Goiro, not in favor of the plaintiff. That is their stand. Rais Goiro means the purchaser should be Rais Goiro. That is why, lordship, they have argued the case like this. Now, whether sum and substance of the case is like this, lordship, whether the trial court or the Board of Revenue can interpret the clauses of the sale deed that it should be Rais Goiro when there is no evidence on record that they have purchased the land in question by the contribution given by the people of the locality. There is no evidence that money has been given by the people of the locality and that money has been utilized for purchase of the land in favor of the plaintiff. There is no evidence on record to substantiate that land has been purchased on the basis of contribution made by the local people of the area. Secondly, Supreme Court has said, categorically stated, that when a sale deed is to be interpreted, whether the purchaser are different or the purchaser has purchased the land in the name of another people or anything, then what should be done by the court? Supreme Court has clarified. I will place the judgment.
the Supreme Court has clarified that when there is a ambiguity in the sale deed, then court has a power to interpret the clauses of the agreement. Court have to go to the recital of the sale deed. In the recital, Lordship will find if they sum and substance in the recital, Lordship can see the recital. That is Exhibit 5. Exhibit 5, recital.
Is it in the memo of appeal?
189.
189.
It is a small matter. It is a small matter, though they are submitting for
189.
189.
Yes. This is a vernacular copy of the
Vernacular copy. Vernacular copy.
Yes.
Borabor, Sri Chutiram Miki. These are the plaintiff, Lordship, plaintiff's father and fathers.
Yes,
parents. And Rice Goido, Hirendram Phukon and Virendram Phukon are the seller. These are the purchaser. They want to say the Rice Goido should be in the Borabor. Land has been purchased by Rice. That is why Borabor should be replaced by Rice Goido. They want to say like this. Their case is like this. The Rice Goido should be in place of Borabor. Then what should be done by the Honorable Court? Supreme Court has clarified this time. When they have disputed that this sale deed has been executed by seller in favor of the people of the locality, Lordship will go to the recital of the claim, recital of the sale deed. Is there any statement in the recital that land has been purchased by the purchaser in favor of the people of the locality? Now I can read the Assamese portion. Guwahati Jilar Kamrup District Kaijor Upolekhe Sob District Guwahati Kanchan Jomi Sab Bikri Khondos Potromide Kanchan Jonge Aji Amar Tokar Aboshok Wat Apunalokor Pra Usit Nogot Mullo Pai Amar Nam or Sotto Dokol Topsil Bonte Jomi Sab Bikri Kore Aji Apunak Lokok Somjai Dilu Bikri Jomi Apunaloke Apnaloke next page to go. কৰি আপোনালোকৰ নামে নামজাৰি আদি কৰি লৈ দখল ভোগ কৰি থাকিব পাৰিব ইয়াত আমাৰ কিংবা আমাৰ ৱাৰিছৰ কোনো ৰূপে অজৰ আপত্তি নাই থাকিলেও এই দলিনৰ বলে এই সকলো অগ্ৰাহ্য অসিদ্ধ হ'ব ইতিপূৰ্বে বিক্ৰেতা জমি কোনো ৰূপে দায়ী গ্ৰন্থ কৰি আবদ্ধ কৰি ৰাখা নাই তেনে আইন মতে দণ্ডনীয় হ'ব বাধ্য থাকিব এদাৰ্থে খুব জ্ঞানে সুস্থ শৰীৰে নগদ হাতে লৈ বুজি পাই জমি বিক্ৰী খাত লেখাই দিলো on 13/5/57. Now in the recital, Lordship will find in the recital there is nothing that land has been purchased by the purchaser in favor of the Rice, and Rice has paid the money for purchase of the land. There is nothing on the recital. Supreme Court has clarified this time. I can place the judgment on this point without going to the other thing of the matter. That is also 2009. 2009 4 SCC 193.
You furnish a copy to me.
This is the crux question of the case. Whether they can claim right over the property on the basis of sale deed. Whether interpretation is necessary. 2009 4 SCC 193.
Yes.
Para 19. Para 19. I'm not reading the whole judgment. Para 19. To answer to the question, Lordship got it. To answer to the question where the parties intended to transfer the ownership should be merely by execution of registration of the deed, whether they intended to transfer the property to take place only after receipt of the entire consideration would depend on the intention of the parties. Such intention is primarily to be gathered and determined from the recital of the sale deed. When recital are insufficient, ambiguous, the surrounding circumstances and conduct of the parties can be looked into, ascertaining the intention and subject of limitation placed Section 92 of the Evidence Act. So, Lordship, in this sale deed itself from the recital I have read, there is not a disclosure that sale deed has been executed by the vendor in favor of the plaintiff herein, that it should be utilized for the local people of the area. There is nothing in the they have not produced any resolution. Their evidence, there is no resolution that land has been purchased by the contribution given by the local people of the area. There is nothing on the record. There is no evidence. I can read the evidence on the record that there is no evidence that land has been purchased on the basis of contribution made by the local people of the area. Secondly, I have already placed that they have produced one title deed. This title deed is obtained, Lordship, after order of the Board of Revenue. That is why we have referred the appeal before the Board of Revenue, and this honorable court has said any order passed by Board of Revenue is subject to the decision of a civil suit. So the documents which has been exhibited as a title deed have no value. Secondly, we have stated the holding. Our holding has been transferred on the basis of Board of Revenue's order. Whether Board of Revenue has a right to interpret the clauses of the sale deed, that it should not be by the purchaser for the rice. Nothing in the sale deed that land has been purchased for the rice. Secondly, Lordship, if sale deed has been wrongly executed by the vendor, is there any suit for declaration that the sale deed has been wrongly executed in favor of the plaintiff? There is no counterclaim. There is any suit declaring or selling the sale deed that it should be in favor of the rice goiro. There is no counterclaim. No suit for declaration by the defendant herein. Till date, no suit has been filed.
Yes.
And what you will find, there is no counterclaim to that effect. In our suit, they have not any counterclaim that this sale deed should be rectified by declaring that sale deed should be in place of rice goiro. It should be rice goiro in place of Borabor. There is no such averments, no claim in the written statement. If Lordship want to hear the matter finally today, or
You will hear it.
No, only a few minutes are there.
Continue. Tomorrow, day after tomorrow, I can also continue. Day after.
because this is the crux of the matter, other points are there. Because they have argued different points in the case. First is, they have argued point to be determination. I have already stated order 41, rule 31. Suit is barred by limitation. According to them, suit is barred by limitation. That is one point. Secondly, they have stated there is no cause of action. Suit has been filed in 2016, but sale deed has been executed in 2057. That is second question. Third question is, we have not prayed for consequential relief in the suit. That is why under section 34 of the Specific Relief Act, suit is barred, according to them. Secondly, plaintiff has prayed for relief jointly against the defendant number 123, 126. That is their prayer. These are the 4-5 questions which they arose in the first appeal. I have to give answer all these 4 questions. Suit is barred by limitation. They have stated in 1957, sale deed was executed, which I have shown in the sale deed. But we have filed a suit in 2013.
16 July 2013. 16 July.
Suit has been filed in India 2013.
16/7/2013.
We have already shown Why 2013? If Lordship the cause of suit is barred by limitation, it is against them. Sale deed was executed in 1957. Till date, no counterclaim, no suit for declaring that sale deed should be executed in favor of the people of the locality. That is Lordship the Kherapani Gaon Unnayan Samiti. Till date, they have not filed any suit.
Kherapani or Kepenism?
Kepenism, sorry, Kepenism. I made wrong. Respondent number 7. They have not filed this suit till date.
Is defendant
Defendant number 7.
defendant not
Defendant number 7.
respondent is
Defendant respondent number admitted no suit filed. We have stated regarding cause of action, when cause of action arose. Lordship will finally see from para 24 onwards of the plain, page 44.
Para number 20?
Para 24 onwards.
Twenty-four of
Plain Lordship. Para 40, page 43. May I submit one thing, Lordship? May I submit one thing? In a joint family, property inherited by 4 sons, that will be divided into 1/4 among the all legal heirs of the father. One of the son can claim right over the property, that is 1/4 share of the inherited property from his father, along with defendant number 1, 2, and 3, who are the brothers. There is no bar in the code of civil procedure that plaintiff, being son of his father, he cannot claim share of the property, or this is 1/4 share of the property, along with their brothers, 3 brothers against the defendant. That is 1/4 share. Court has declared jointly declaration of right title interest along with defendant number 1, 2, 3, 4 with the plaintiff, because land has been purchased in this question by the parents of the plaintiff as well as defendant number 1 to 4. That is why trial court has decreed the suit. How decreed the suit? Lordship will find at page. I can take your Lordship. Page 26 again. Suit is decreed on contest with cost. Right title interest of the plaintiff in respect of the suit land described in Schedule B hereby declared jointly along with defendant number 1 to 6, and plaintiff are also entitled to collect the rent of traders of Lokra Saturday, weekly, and daily market to the extent of share they are entitled and agreed upon by the parties who are jointly entitled to collect the rent. So joint decree has been given along with defendant number 1 to 6, who are the purchaser of the land from their vendor, means their father. That is why suit has decreed according to our share of the land, proportion to the share of the land. Secondly, Lordship will find they have prayed that we have not prayed for consequential relief. Consequential relief is rent. We are claiming rent. That is why trial court has decreed that we are entitled to share. Traders are collect rent from the traders of Lokra weekly market, daily market, to the extent of share they are entitled and agreed upon by the parties who are jointly entitled to collect the rent. That is a consequential relief. So, Lordship, regarding consequential relief, I have given a photocopy of the dictionary meaning of consequential. In the first page itself, Lordship will find what is the consequential.
Kabe.
उसको खुल दिया था क्या? This is the Oxford Dictionary's meaning. Consequential, following is a direct result or effect. She was injured and suffered consequential loss of earning. That is consequential. If my right is declared, I am entitled for the rent. That is consequential. If my right is declared, I am entitled to the rent. That is a consequential relief. I again take your lordship. Page 42 of the appeal memo. Lordship, got it, page 42.
Yes, sir.
Para 18. That the relief for declaration of right, title, and interest of the plaintiff over the land, and also further declaration, right of the plaintiff to get their due share in the total collection of the amount have been necessary due of same circumstances of the case, further decree for realization of the amount from the defendant, which was received by them from traders of the market with effect from 1/7/2011 to 30/6/2013. As such, plaintiff have been compelled to file this suit. Now, para 19. Defendant collects at least 5,000 per day from the regular market. Besides, the defendant collect 15,000 from the weekly market, which is held on Sunday. There are permanent shop houses, and shop houses are let out to the tenants on monthly basis, from whom defendant collects at least 90,000. There are at least 3 lakhs monthly income from the Schedule A land. Defendant themselves collect and keep the entire amount of the plaintiff, are deprived their due share. Earlier, plaintiff also used to collect the same amount from the weekly market, but from 1/7/2011, that is a specific date. 1/7/2011, plaintiff are not allowed to collect the amount from the weekly market, and defendant strictly asks all traders of the market not to pay any amount to the plaintiff. That is the cause of action. That market set up by the plaintiff and defendant 126 in the year 2006. Guwahati Municipal Corporation assessed the property and allotted the holding number in the name of the co-partner. That is holding number 545, ward number 13. Lordship, I have already shown the holding. Lordship has noted it down earlier occasion. That holding is in my favor. Said holding was transferred in the name of the appellant herein after order passed by the Board of Revenue. Already I have shown, Lordship has, I think, noted it down. The same holding 545 has been transferred to their name after order of the Board of Revenue. And that is why this honorable court in WPC number WPC number last portion. WPC number 246, page number 246, WPC number 63 of 2009, page 246. 246, last portion.
Yes.
In view of the circumstances, learned counsel by the parties, this consent order is passed dismissing the petition as infructuous, with the observation that the order dated 1/12/2008 passed by the learned Board of Revenue shall be subject to the decision of title suit number 277 of 13. That is the Lordship title suit number against which they have prevailed. So any order subsequently passed on the basis of Board of Revenue is not tenable and applicable. What they have stated, one, Lordship, the holding number, one patta has been issued after Board of Revenue order, interpreting that it should be rise borabor. Khepinijol. Lordship will kindly see page 243 again, the Board of Revenue order. It starts from 238.
No, that operative person?
Operative plus page 24. How it is interpreted. Lordship will pay
Para 24.
Para 24. After hearing the learned, the middle portion. It is to be presumed, Lordship got it. It is to be presumed that the word rise goiros should have been before the word borabor in the cell deed. How court can presume, Lordship? Supreme Court has clarified that that cannot be interpreted when there is a discrepancy in the recital. Recital, there is no discrepancy that the land has been purchased by the Khepinijal Committee of Rise Goiro. Secondly, the restriction of what I have stated, that the society under whom they are claiming right, that has been registered, page 223 in 2008. page 2 to 3.
On the other day, you have shown it.
Lordship. Exhibit G, job,
Page number 2 to
3.
yes.
That is 2008,
Hmm.
on the basis of which they are claiming right. That is Kepinizol Gaon Union Committee. It is registered in 2008. 57 land has been purchased, and they are claiming that this society is the owner of 1957 on the basis of this restriction. Is it possible, Lordship? And there is no document that this society was existing in 1957.
Hmm.
No document.
Hmm.
And Revenue Code has no authority to interpret a sale deed, Lordship. They have no power. And declaration of right title and interest is on the basis of the Civil Code. Revenue Code has no right to declare right title on interest on the basis of a document.
Hmm.
Now, para 21 again, Lordship, page 43. Page 43.
Hmm.
That the market set up in Schedule B land jointly belongs to the plaintiff and defendant number 126. However, defendant number 124 secretly entered into a pact with defendant number 7 to 11, allowed them to collect the rent of the market. Defendant number 7 to 11 have got no right whatsoever over the Schedule B land. They are outsider. The plaintiff and defendant number 126 are co-sharer of the Schedule B land, and they have got equal right over the Schedule B land. Whatever income accrues from the Schedule B land, they are equally entitled to get their share and proportionately to the extent of their share over the land. Plaintiff number 1 and 2 are legal heir of the predecessor of John Mickey. They are entitled to 1/4 share of the total income derived from the market. That is 75,000 of the total income and income of rupees 3 lakhs. Plaintiff number 1 and 2 are totally deprived of collecting the rent from the market with effect from 1/7/2011. Plaintiff number 1 and 2 are entitled to get the arrear amount of the rent which are already collected by the defendant from the traders, but they refuse to give the amount to the plaintiff 1 and 2 in spite of repeated demands. Plaintiff number 1 and 2 are entitled to get 75,000 per month from defendant with effect from 1/7/2011 till date. Defendant are liable to pay rupees 75,000 monthly as a share of plaintiff number 1 and 2 with effect from 1/7/2011 till 30/6/2013. That is the after date of filing of the suit. Plaintiff number 1 and 2 are entitled to realize the total amount of rupees 18 lakhs from the defendant jointly and severally with effect from 1/7/2011 to 30/6/2013. Defendant also, thereafter also defendant are liable to pay amount of 70,000 each month. Plaintiff demanded the defendant for payment of the said amount on 1/6/2013, but that there is no response from the defendant. Plaintiff, para 23. Plaintiff number 3 is the daughter of late Shutiram Mikir, who was also one of the Schedule B land. This Shutiram Mikir died leaving 4 daughters, namely Benu Mikir, Senu Mikir, Junaki Mikir, and late Soneshwar Mikir. Legal heir of late Shuti Mikir are entitled to 1/4 share of the income of rupees 75,000 out of the total income of rupees 3 lakhs. Late Shutiram Mikir left 4 daughters, and 4 daughters are equally entitled to 75,000. Accordingly, plaintiff number 3 is entitled to get 1/4 share of the said rupees 75,000. That is 18,750 per month with effect from Iman till date. Accordingly, plaintiff also claimed rupees 4,50,000 of the defendant with effect from 1/7/2011 till 30/6/2013. She is also demanded the defendant for payment of the said amount on 1/6/2013, but defendant refused to pay the amount to her. Plaintiff are not getting a single furning from the collection of rent schedule balance with effect from 1/7/2011. Earlier till 1/7/2011, plaintiff repeatedly requests the defendant to give their share and allow them to collect the rent from the market to the extent of their share as they used to collect earlier till 30/6/2011. But defendant forcibly illegally debarred the plaintiff from collecting the rent from the market which set up themselves in the year 2006. That it is pertinent to mention that the purchase of the land had continued to possess this land jointly. That is the weird, purchasing jointly. After date of 3 purchases, their legal heir also possess the suit land jointly, and land has been divided among co-sharer by meets and bounds till date. Plaintiff are still in occupation of the suit land. That is why we have not claimed for declaration of recovery of possession. Plaintiff number 3 had got a shop in the market. And she herself used to run the shop, but due to personal difficulties, she have up the business in the month of November 2010. That the right title and interest of the plaintiff over the Schedule B land have been clouded on account of the judgment of the Revenue Board and also account of the deprivation of collecting rent in the market by the defendant. Judgment of the Revenue Board dated apparently wrong without any basis. Though same has been challenged before the High Court, if the plaintiff win the case, High Court relief granted by the High Court would not be sufficient. Moreover, declaration of title over the Schedule B land has necessarily been disposal of the cloud created by the defendant claiming that property belongs to RISE. Plaintiff are also compelled to file their suit for realization of area rent collected by the defendant from traders of the market from 1/7/2011 till 30/6/2013. Relief for permanent injunction is also required to restrain defendant, their man and agent from disturbing the plaintiff in collecting the rent from the traders of Lokra, Charlie Bazar and weekly market, organized and held over the Schedule B land to the extent of their share. Appointment of the receiver is also necessary in case of plaintiff are not allowed to collect the rent. The cause of action for the suit arose on 1/7/2011 with the defendant restrained the plaintiff from collecting the rent. In reply to that, what has been stated, Lordship, in the WS? Lordship, I'll take you to the WS.
Mr. Goswami, it is already 4:45.
That is well, Lordship, I'm submitting. I can continue with.
Okay, day after tomorrow.
No,
Possible.
next week, Lordship.
Next week I will be there. Because I have.
They have completed the argument next week.
No, your next
We have
week
lots of some
problem is
problem
I will
this
be
week.
there. I cannot stay back so long.
They have completed the argument.
No, day after tomorrow, I have to reply because he's taking all the things out of that. So day after tomorrow, you're not.
Lordship, 3 hearing cases has been fixed, so day after tomorrow. That
Yeah,
is
how
why,
you-
Lordship. If Lordship,
No,
we pray-
okay, all right. Day after tomorrow at 2 p.m.
Yes, sir.
In the first half, you finish your work.
Lordship, I cannot agree that I can finish. Lordship will, as per Lordship
No, you
discretion,
try to-
as per Lordship discretion, no adjournment is given by some court, Lordship. Accommodation is necessary. That is well, Lordship. I'm ready to
No,
argue.
no, that's all right. But as per his convenience, both the parties' convenience, not
Lordship, that
only
is why I am submitting next week.
Next week, how can I stay back?
If Lordship, they are insisting, I'll try my best.
Okay. No, or else Mr. Chaudhary, you can attend from there also, Delhi also.
Video conference also they can do.
Yes.
Because I have to carry all these files and problem will take care of.
No, you have to file only the reply.
No, reply I have to do because say he's going in a different direction. I have to reply it to clarify everything, Your Honor. That's why. Let it be 2 o'clock, Your Honor.
No, I don't have any problem. Problem is yours, not
Yeah,
mine.
I know. Tomorrow, let's start it tomorrow. We'll see, Your Honor.
Okay, let us try on day after tomorrow.
Yes, if you.
Heard Mr. Chaudhary, learned counsel for the appellant, and Mr. Goswami, learned counsel for the respondent. List the matter on Thursday as part heard. At
2 p.m.
2 o'clock.
At 2 o'clock. Lordship will keep the judgment, Lordship. I give it a copy, Lordship can also go to the judgment.
Oh, okay.
From production list,
Obliged.
item 1.
Because my learned was supposed to give your judgment to your lordship regarding that decree can be given to defendant also. He told your lordship that. Supreme Court judgment yourself.
High Court rules do not say that I should give a copy to the judgment to him.
No, I'm not saying. You to address to the court that you have a judgment that decree can be given to your defendant. You are Supreme Court. You told that.
No.
I am placing these cases, Lordship.
That's all right.
No, that's all right. If it is available, you furnish a copy to the court.
That is what I.
I have already given the Lordship.
Okay.
I have already given the judgment.
Okay.
Joint decree can be given. That is admitted position. Law is already settled.
Not a joint decree. There's no partition.
Already I have pointed out, Lordship. Joint decree in case of family 4 son can file, 1 file son can file a suit. Declaration of right of 1/4 share along with his 3 brothers.
But if
Where is the bar?
If
Where
the
is the
brother
bar?
they say they don't have a title, how can it say they are hostile to the whole thing? WS says so. He
Okay.
sidetrack those issues.
Okay, Mr. Ahmed, today it is already time is over.
There only one small issue that on the
Maybe that let us take it on Friday. Oh, no. So Thursday. List on Thursday. কালাম বুলি ভাবিছিলো মই কালাম নহয় তালুকদাৰ নেকি চহৰীয়া নেকি পাতটো আৰু মৰ্যাদাটো ৰাখি থৈ এইটো